Good morning, everyone. Welcome to the November 7th, 2025 meeting of the California Privacy Protection Agency Board. It's 9:07 a.m. and we are meeting in San Francisco. I'm pleased to be here with my fellow board members and members of the public, each of whom are both here in person and virtually via Zoom. Before we get started, a few quick reminders. Please make sure your microphone is muted when you are not speaking. If you are here in person, please silence your cell phone to avoid any interruptions. And importantly, please do note this meeting is being recorded. Today, as you can see, we have 3 board members participating in person. Board member Alistair McTaggart is joining us remotely. Good morning, Board member McTaggart. And board member Brandy Nanaki will not be in attendance. CPPA staff are also present in person, and we continue to offer the public the opportunity to watch and participate in today's meeting virtually. Please bear with us if we experience any technical issues, and we will pause to address them if we need to. The physical side of today's meeting is being held at the California Public Utilities Commission in San Francisco. We really appreciate the CPUC's hospitality in not only allowing us to use our auditorium, but also providing the AV backup and assistance today. Thank you to the gentleman in the control booth in the back. Today's meeting will follow the Bagley-Keene Open Meeting Act as required by law. The agenda and all supporting materials are available here in San Francisco and on the CPPA website. You may notice board members referring to their laptops, phones, or other devices during the meeting. They are using the devices solely to access board meeting materials. The board welcomes public comment, and I will call for it as we move through the agenda today. Please do note the rules for public comment. Each speaker will have 3 minutes to make their comment on any given agenda item. Under the Bagley-Keene Open Meeting Act, both board members and the public must limit their discussion to the item being discussed that's on the agenda, and not discuss items outside of the agenda. Accordingly, please limit your comments to the agenda item being discussed. That said, there are 2 exceptions to this rule. First, we have an item for general public comment. This is number 8 on our agenda for today, if you'd like to look, titled Public Comments on Items Not on the Agenda. When we discuss this item, members of the public can comment on topics not on today's agenda. Please note that this item is for the public. The board cannot itself comment on items not on the agenda. In addition, the board can only listen to comments that we receive. Second, if you have a suggestion for a topic that the board should consider at a future meeting, you can bring that up under agenda item number 9 today, which is designated for proposing future agenda items. A little bit about meeting logistics. This is a hybrid meeting. Public comment is welcome both in person and via Zoom. After each agenda item, I will I'll provide an opportunity for questions and discussion by board members. I will then invite public comment, and each speaker will have the 3 minutes per item I mentioned. If I happen to forget to call for public comment on an item, just raise your hand either on Zoom or in the room physically, and the moderator will make sure you're recognized. If you're joining via Zoom and you wish to speak on an item, please wait until I call for public comment and then use the raise hand feature under reactions, which is located at the bottom of your Zoom screen. If you're joining by phone, press *9 to show the moderator that you are raising your hand. That's *9. And then when it's your turn, the moderator will call on you and unmute you. You can make your comment. And when you are finished, the moderator will mute you if you are on Zoom, and if you are on Zoom. If you're on the phone, apologies, you need to press *6 to unmute yourself when the moderator calls on you, and she will mute you again when you're done. Please note that the board cannot see you if you're a Zoom participant. We can only hear your voice. If you'd like, you may identify yourself, and we do find that helpful, but this is completely optional. You can either use a pseudonym or no name at all, and you can use a pseudonym when you log into Zoom. If you're here in person and wish to comment on the item, please wait for the public comment period to be announced and form a line at the podium to my left and downstage to the right. When you called, please speak clearly and directly into the microphone so remote participants can hear you and your remarks are recorded in the meeting record. Again, it's helpful to us to state your name or a pseudonym, but that is in no way required. These hybrid meetings can be technically complex, so we appreciate your patience. My many thanks to Serena Carwile, our moderator, Mr. Francisco Hernandez, and Mr. Robert Stanford for managing the technical side of today's meeting. And I was waving at Francisco in the control booth a moment ago. If you're attending remotely and experiencing technical issues, please send an email to info@cppa.ca.gov. That's India November Foxtrot Oscar at CPPA for California Privacy Protection Agency at ca.gov. This inbox is monitored throughout the meeting, and we will figure it out and probably pause the meeting and resume once the issues are resolved. We will take breaks as needed, including a lunch break. I'll announce each one and let you know when we will resume, an estimate of when we will resume. Please note that agenda item number 10 is a closed session item. We'll likely call that during the lunch hour to use the time efficiently, and I will let the public know when we go into closed session and when we return to open session. My thanks to the board members for their service, to everyone helping to make today's meeting possible. Special thanks to Executive Director Tom Kemp and General Counsel Philip Laird, who are serving as the sort of master of ceremonies and the counsel for the meeting, respectively. And I would like to thank and welcome our moderator, Ms. Serena Carwile, and ask her to please conduct the roll call.
All right. Board Member Hamer.
Present.
Board Member Liebert.
Present.
Board Member McTaggart.
Here.
Board Member Nunnicki. Chair Urban.
Present.
Madam Chair, you have 3 present members and 1 absence.
Thank you.
Oh, I apologize. You have 3 present, 1 remote, and 1 absent.
Excellent. Thank you very much. Under the current Bagley-Keene Meeting Act rules, we have established a quorum. I would like to thank the board for that and let the board members know we'll take a roll call vote on any action items. With that, we'll move directly into agenda item number 2, which is an annual update on legislation and discussion of potential agency proposals for the upcoming legislative session, and that will be by the agency's Deputy Director of Policy and Legislation, Maureen Mahoney. Please turn your attention to the materials provided for this agenda item, and I will turn it over to Ms. Mahoney whenever you're ready.
Great. Thank you, Chair. Members of the board, appreciate the opportunity to provide an update on our legislative work and to present staff's recommended legislative proposals for 2026. So first, I'll provide a brief federal update, then a very brief multi-state update, California 2025 legislative session wrap-up, and then finally turn to the 2026 legislative proposals. And then I was planning to pause after each of these sections, if that's okay. Okay, next slide, please. Great, so I'll start out with a federal update. As you know, there's been continued focus this year on legislative proposals on the federal level that would seek to preempt state laws. And at the last meeting, I mentioned that the House Energy and Commerce Committee had developed a working group to work on a legislative proposal for privacy. We've heard that they hope to have something released by the end of this year, so we're on the lookout for that. There's also a high likelihood that legislation similar to a provision that was initially added to the One Big Beautiful Bill Act that would have a 10-year moratorium on enforcement of state AI and ADMT laws will resurface at some point in another vehicle. So to that end, later this month, Executive Director Kemp and I will travel to DC to meet with legislators and other stakeholders. And yes, we have nearly full schedule already, even in light of the shutdown, thanks to the dedication of congressional staff. And this trip has 3 main goals. First, we'll be holding meetings with legislators that we have relationships with and that we communicate primarily remotely, but to strengthen those relationships in person. Also to develop new relationships, which is best done in person, and then also to raise awareness of the CCPA and the DELETE Act, and particularly the unique protections that exist in California requirements to honor opt-out preference signals, new requirements for browsers with respect to these signals that will be going into effect next year, the drop system that will really revolutionize the privacy experience for Californians, and of course the ADMT regs that are so important for privacy. So ultimately, we hope these meetings will allow us to directly and effectively communicate why the agency opposes efforts to preempt state laws and why it's so important to have a federal privacy law that sets a floor and allows states to adopt stronger protections. And that is the federal update. Okay, moving to a quick multi-state update. So we monitor states considering privacy and ADMT legislation as part of our mandate to work towards consistency and privacy protections where possible. So most of the state legislative sessions have wrapped up for the year. A few states are still in session, and of those states, 4 of them, Massachusetts, Michigan, Pennsylvania, and Wisconsin, have comprehensive consumer privacy laws pending. So 2 of these bills, Massachusetts and Pennsylvania, have passed one chamber and are in the second chamber. So we're watching those most closely. And the Massachusetts bill in particular is pretty strong. It has strong data minimization standards, and it prohibits the sale of sensitive data, similar to the Maryland law that recently went into effect. The others are generally very similar to many other state privacy laws. They do share key features with California's law, including a requirement to honor opt-out preference signals, and a prohibition on dark patterns. So we'll continue to monitor these bills and provide technical assistance as appropriate and keep you updated if any of these move and are signed into law. And that's a multi-state update.
Can I ask a quick question?
Yeah.
When are these sessions wrapping up?
The end of this year.
The end of the year, okay.
They'd have to move pretty quickly.
Yeah, thanks.
Okay, next slide. Okay, so now a quick wrap up on the California legislative session from last year. So at the last board meeting, the legislative session had ended, but we were still waiting for the governor to weigh in on several of the bills we were tracking, so we're just going to close the final loop today. So it was a busy year. Over 75 privacy and AI bills were introduced in 2025. Of those, more than 20 were signed into law. And around 5 of these bills passed the legislature, but were vetoed by the governor. So we'll go into a bit more detail about some of these in the slides. Next slide, please. Great. So first, a quick update on the bills on which we had a formal position. Again, we were thrilled that AB 566, the California Opt-Me Out Act, our sponsor bill, was signed into law. Very much appreciate Assemblymember Lowenthal's leadership on this. And then also very grateful that the California Attorney General's office came on in support. And that will go into effect January 1st, 2027. SB 361, oh, sorry.
Can we just take a minute again and say, wow, that's just fantastic. It's nation leading. In many ways, I think it might be internationally leading. And it's truly an extraordinary accomplishment by the agency, by the legislature, by the governor, all the stakeholders and groups that pitched in. And it's just really exciting. And I think for the agency itself, a reflection of just the tremendous work of the staff. And, you know, I think we've said this before, but it's rare to get a veto on a bill and the very next year pull out a victory through tremendous negotiation and effort. And you all should be really proud. I certainly am. I think this is really exciting for Californians, and I think for the country ultimately, because it's certainly going to be a wonderful model for states across the country.
I've already seen news reports about how California's OOPS bill will already have protective effects for people because it goes to the browser. And then it's up, of course, to the browser company to decide whether or not to try to limit it to California. But it's a place in which California can lead and really lead in a way that is helpful to Californians, but also more broadly. I really want to second Mr. Liebert's remarks. I won't repeat them, but I will simply add that I know there was really careful attention to the technical aspects of the bill, both legislative and technical. There was attention to those last year, but this time there was more time to be able to put them into place, and that was very important, as well as the broadening of the coalition, which I think was simply a matter of ensuring that that a broader coalition were aware of the issues and of how this would be helpful. So I'm really delighted, and I think this was, as Mr. Liebert said, a tremendous accomplishment. And we really commend staff and everybody who worked on this. Obviously, the sponsor and the sponsor's office, and everyone in our partners at DOJ and GEO as well. So thank you.
I'd just like to add, too, that there were some very substantial technology companies that pitched in ultimately to have great discussions with our staff and throughout the process. And it was an example of the opportunity to ultimately work together with the industry as well as others to try to reach a conclusion. And I think that's a great model.
Absolutely. Mr. McTaggart.
Sorry, thanks for this. Thanks for that. I think it was a little over a year ago that I sat on stage and said, how disappointed I was that the previous version of this had not passed. And first of all, kudos to Assemblymember Lowenthal for pushing this. As Mr. Liebert just said, it's rare to do this again, having just gotten a bloody nose, to keep on, to bring it up again, have the courage to do that. And then real kudos to Ms. Mahoney and Director Kemp and all the team for the coalition they assembled. That was the difference this year. The difference was, a little more negotiation with the tech companies and having a really effective coalition. And I just keep my hats off to the team in our agency, because I think we had a lot to do with it, honestly. I think obviously the sponsor and his office did. And together, we did this thing, and this was always, the vision with the California privacy legislation, is that it would be a base upon which we could grow privacy, sensible privacy, legislation, and that's clearly what's happened here. This is the benefit of the amendment process in the original legislation, so that anything that builds on privacy is fine. And so this is what this is doing here, and I know the way that our original legislation was a model for the country, this will be a model for the country. And one question I had for Ms. Mahoney is, has any other state even kind of talked about doing this, Ms. Mahoney? And in light of what's happened here, is anybody also talking about that? And then, so I have sort of two questions for Ms. Mahoney. That's one. And then you went through the other state bills. Are we still, in your mind, the strongest, or is anybody stronger than us? I mean, I know some obviously cover nonprofits, which we don't. But so those sort of two questions for you. Is anybody talking about a 566 kind of ish action? And then how do we rank still? Thank you.
Great, that's a good question. So no other state that I'm aware of currently has a bill pending that would extend the opt-out preference signal requirement to browsers, to require them to offer it. I think a lot of states are very interested in watching what happened in California, but the Connecticut Attorney General's office has publicly said that they think this is a really good idea. So we may see states like Connecticut or others consider such a proposal, especially now that this one has been signed into law in California. As to the question about whether California is still the strongest, I mean, first, I think we have to look at California's protections as being broader than just the California Consumer Privacy Act. Obviously, the DELETE Act and the other existing laws in California significantly bolster California's protections. But other states are continuing to ratchet up the protections. Maryland, in particular, that went into effect in early October, has a lot of features that California may want to take a look at. For example, a prohibition on the sale of sensitive information and covering nonprofits. So I think it is a really exciting time for California in that we've been the lead in so many areas, but there are always additional areas to consider.
Thank you, Mr. McTaggart. And Ms. Mahoney, please go ahead.
Great, and thank you for having the chance to celebrate that victory. Staff was very pleased as well. So next, SB 361 from Senator Becker. That was another bill we supported that was signed into law, and that increases data brokers' disclosure requirements under the DELETE Act. And that goes into effect January 1st, 2026. And that'll be discussed a little bit more in another item. And then finally, SB 470 from Senator Laird, having to do with the Bagley-Keene Open Meetings Act, extending the existing teleconferencing requirements for 10 years, which we supported, was also signed into law.
And that's why Mr. McTaggart can join us remotely. So we like that law.
Yay.
Let's see, and then a few two-year bills to talk about that we took a position on. AB 302 from Assemblymember Bauer Cahan, which required our agency to obtain and maintain a list of state elected officials and submit deletion requests on their behalf under the DELETE Act, which we had a supportive amended position on. So didn't advance this year, but may come back next year in 2026. And then second, we had a support position on AB 322 from Assemblymember Ward, which would amend the CCPA to increase protections for location data, including to prohibit its sale. So that may come back next year as well. And then while we're discussing, oh yes.
A quick question, support if amended, what's the amended issue, and is that what might make it work next year?
Great, yeah. So I think the biggest concern with that bill is that what the question is why we were supportive amended. Yeah, I think the biggest concern was tasking our agency with collecting and maintaining this list of elected officials in the state. There are many, many, many of these, and there are other entities that are more suited to do that, especially under the aggressive timelines under the bill. So I think we're going to continue to work with the author and try to address these issues.
Thank you.
Great. And then while we're discussing two-year bills, I wanted to flag a few bills that we didn't have a position on, but we were watching because they related to us that didn't advance the session, but we may see them again next year. And those include AB 364 from Assemblymember DeMaio that required consent to maintain a consumer's personal information in a foreign jurisdiction. SB 354 from Senator Limon, which provided comprehensive privacy protections in the insurance space. And then SB 435 from Senator Wahab that removed the publicly available exception for sensitive personal information in the CCPA. So we may be talking about those at a future meeting. And next slide, please. And then just a final wrap up on our watch bills, AB 1018 from Assemblymember Bauer Cahan that had to do with automated decision systems. It's placed on the inactive file. I think we talked about at the last meeting. It means it did not advance this year, but it could come back next year. AB 1043 from Assemblymember Wicks that has to do with age signals. That was signed into law and becomes effective January 1st, 2027. AB 1064 from Assemblymember Bauer Cahan having to do with kids and AI chatbots. That was vetoed by the governor, but in response to the governor's veto, Common Sense Media filed a proposed ballot measure that has many similar provisions as AB 1064 and a few additional ones as well. Of most significance to our agency, it would amend the CCPA to extend opt-in protections to kids under 18 as opposed to kids under 16 is what we have currently in the CCPA. The other provisions of the measure operate outside of the CCPA and don't directly affect us or task us with responsibilities. For example, would prohibit operators from offering chatbots that could cause harm to children. So my understanding is that they'd need to meet the signature requirements by spring to get on the November 2026 ballot. So we'll be watching that. And then finally, SB 7 from Senator McNerney was vetoed by the governor that would have regulated the use of automated decision systems in the employment context. Next slide, please. And I wanted to provide an update on our legislative engagement this session. With Executive Director Kemp joining us near the beginning of the year, we made a concerted effort to reach out and try to meet with almost every legislature. We did direct outreach to a substantial portion. We reached out to 88% of the Senate, 75% of the Assembly. And that led to numerous meetings. We had meetings with over 52% of the Senate or their staff, 40% of the Assembly and their staff. The Assembly is twice as big. And that outreach is ongoing, and this doesn't include the meetings that I had alone with staff. And in the early summer, we also did a legislative briefing for staff where we talked about the agency's priorities and got feedback, talked about the CCPA and the DELETE Act. And those were positively received, and we're encouraged to do more of these in the future. Next slide, please. Okay, so looking ahead to the 2026 legislative session, I wanted to present some bill proposals for board consideration. But before I do that, I wanted to provide some information about the various ways that the agency could get involved with bill proposals that the board would like to endorse. So specifically give a little detail about the differences between sponsoring a bill and supporting a bill. So sponsorship, which is what we did for the Opt Me Out Act, is typically a more involved process. It involves staff working with the legislator to draft the bill usually. And once drafted and introduced, staff typically would engage with stakeholders, potentially draft amendments to address concerns and provide information about the goals of the bill. And then finally, staff would communicate the agency's support through letters or testimony. When the agency supports a bill, it's usually a lighter lift. The legislator or their sponsor typically drafts the bill. Staff would work with the author to provide technical assistance. And we would communicate the agency's support, but probably through letters, but probably not testify. And additionally, I should note that staff also provides technical assistance to support legislators on bills that deal with the processing of personal information, even if the agency doesn't have a formal position pursuant to our statutory obligation. Next slide, please. Okay, so staff have prepared 3 bill proposals that would amend the CCPA for the board's consideration. So this is more proposals than we've done in the past. The opt-out preference signal bill is the only one we've sponsored in the past. But we've heard from legislators that they would like a variety of ideas to choose from when planning bills for the upcoming session. So I was planning to just kind of go over the 3 at a high level and then discuss them at the end, but also feel free to ask questions as they come up. So we've developed proposals that would meaningfully increase privacy protections for Californians. They reflect input from staff across the organization, including legal and enforcement. And we welcome the board's input and would recommend that the board approve these proposals for presentation to legislators and allow staff the discretion to determine if a proposal should be sponsored or supported as we work with the legislators, because often these decisions have to do with who the author is and what level of involvement they want from a sponsor. And if the proposal were to turn into a bill, staff would bring the bill before the board for consideration, likely in spring. So moving to the proposals, the whistleblower proposal would add comprehensive whistleblower protections in the CCPA. So as you know, the practices of tech companies are often highly technical and sometimes opaque. It can be difficult and time-consuming to identify potential violations. So employees are often in the best position to identify potential violations early on. So whistleblower protections and incentives can help bring these unknown violations to light and enhance the agency's ability to enforce consumers' privacy rights. So we would propose 3 components to this bill, which is similar to the SEC's successful whistleblower program. So first, an award program to incentivize whistleblowers to come forward with information. Second, a special designation program that enables the enforcement division to collaborate with the whistleblower attorneys on certain cases and allow whistleblowers to share in the proceeds of an administrative fine. And finally, anti-retaliation provisions to protect whistleblowers. So the award and special designation components would help incentivize whistleblowers upfront, and then the anti-retaliation component would protect them after they come forward. And regarding the special designation aspect of the proposal, to be clear, it would allow whistleblowers to share in awards and receive attorney fees, but without the right to pursue violations on their own. So some laws allow whistleblowers to litigate matters on their own, similar to a private right of action, and our concept is different from that. Instead, we propose to allow for whistleblower awards in matters that we designate based on whistleblower submissions to our agency, but it would not involve a similar private right of action. Okay, so that was whistleblower.
Can we pause and talk about, yes, please, Ms. Hamer.
So I understand that we get about 150 consumer complaints a week. And so I'm just from the business model, business case of the whistleblower without commenting on, the merits of it. Do we have the bandwidth to bring on more? Do we think that employees are going to, be more likely to come forward than consumers? There's a lot of questions, but it's all kind of going to the same place in my brain to try to get kind of an ROI on this. Of the 150 consumer complaints, roughly what percentage are meritorious? And roughly what percentage goes to action? And then do we have extra bandwidth to be able to take on another category of complaints?
Okay, those are great questions. I think I'm going to phone a friend.
I know, I'm sorry to blindside you on that.
Could I follow up with on Ms. Hamer's question as well, as Mr. Macco joins us? Welcome, Mr. Macco, the enforcement head. My understanding of the value of whistleblowers in this instance could be wrong, but I saw this as an expansion of resources for the investigative team at the agency, because it's very difficult to get information from outside of the companies, and this would be a way to gather information. So while it would require some resources, it would be additive to resources. At least that's how I read the memo. And maybe Mr. Macco, you can help us sort of understand the cost-benefit analysis here.
I'm happy to weigh in. Good morning, everybody, and
Sure.
thank you for the opportunity to address these questions.
Oh, sorry, Mr. McTaggart, I apologize. I
Yeah.
think you might have a question related to the pot you've got. So Mr. McTaggart, please go ahead.
Yes, thank you, Chair. Just Mr. Macco, as you address it, could you also address one provision, I think, from some whistleblower laws, and this gets directly to Member Hamer's kind of question is, if the person bringing the whistleblowing or coming up with the issue, would we have to approve it? And if we say no, we don't think it's an issue, is it dead? Or can they, I know we're not having the private right of action, but can they, I don't know, take it to the Attorney General's office or something? Just explain what there is. I think it's a very pertinent question. Like, do we have to review hundreds of complaints and decide which ones have merit now? So what does that do? Thank you.
Great. Okay, so I'm just going to kind of paraphrase 4 different questions that I'm hearing, and I'm happy to answer those, and we can continue to talk about it as we go. For context, I should confess that whistleblower provisions and whistleblower programs are near and dear to my heart. I spent more than 10 years at the Department of Justice and at the SEC before I came to the agency, and I've personally handled a large number of whistleblower cases as a government lawyer. I know the value of those cases in my previous professional life, and I can see the potential here for how we could use that in a privacy context. Let me get to each question. So the first question is about consumer complaints versus whistleblower complaints in general. And let me just draw a big distinction between consumer complaints that we currently receive and whistleblower complaints. So you're right that we receive about 150 or so consumer complaints every week. Consumer complaints are very different from whistleblower complaints. At any agency, including the U.S. Department of Justice, Department of Health and Human Services, other federal state agencies that have whistleblower provisions and protections, they all receive consumer complaints too. Those are kind of like hotline complaints. And there's a large volume of those at any of these agencies, including certainly ours. Whistleblower complaints are a very small subset. They're totally different. They're not even a subset because they're not consumer complaints at all. These are a specialized form of complaint that is more than just an allegation. It is an evidentiary submission to the agency, prepared by an attorney, a whistleblower attorney who specializes in these matters, and lays forth the allegations of a violation combined with the support for it. And the whistleblower typically has to be an original source of that information. You can't, read about something in the newspaper as a whistleblower and say, this looks like a violation, I'm going to be a whistleblower. You need to be in a position to have some original information to show the violation. Often it's an employee who would come forth. So the volume of these should be a lot lower than the number of consumer complaints. But that kind of leads me to the bandwidth question. Do we have bandwidth as an agency to handle those kinds of matters? And I would say we do, and here's why. In a whistleblower complaint, because our concept, the proposal that Ms. Mahoney's articulating, would have whistleblower attorneys involved. For matters where where enforcement wants to partner with that attorney, that whistleblower to develop it, let's say it looks promising, it looks like a violation, there would be a significant amount of collaboration at that point between our agency and the whistleblower attorney. The proposal here is to actually give us the discretion to decide, which of those cases warrant a special designation, which of those cases warrant this partnership. So we would always kind of control the switch about the volume, but we would also be able to leverage our resources with the whistleblower attorney who can help develop the case and kind of share the burdens of building a case. So I feel comfortable about that. There was a question about are employees more likely than consumers, I think, to submit complaints, whistleblower complaints, and the answer to that is yeah, absolutely. They wouldn't necessarily have to be employees. They could be contractors who have some special knowledge. Often in these cases, you may even have a non-employee, but somebody who has some specialized knowledge of a violation come forward. And that's viable potentially too. And then the last question from Board Member McTaggart related to what happens if the Enforcement Division looks at a particular whistleblower complaint and passes? Is it dead? Is it, what happens to the whistleblower complaint at that point? And in that situation, it would, under this proposal, it would, the Enforcement Division would not kind of specially designate that matter. We may or may not then be investigating. We probably would not be, or we would determine that that is not something we should spend the resources on right now. And I think we need to work out the details about whether, this program, as Ms. Mahoney's articulated, it's designed at the administrative level. So it's not designed with a judicial component in mind, because Board Member McTaggart asked about, could that whistleblower go to the AG's office, for example?
Could I interject
Please.
briefly? And Mr. McTaggart, please correct me if this is incorrect, but underlying your question, I thought I heard, and if not, I have a question about the protections attaching. If the agency doesn't pick up the complaint, would the person still be protected? And I want to alert you that Mr. Liebert has a question as well, but maybe we'll let you answer this and then.
Yes, that's a very important question because under, for example, whenever you have a whistleblower, somebody who has inside information, they are taking a risk to their professional reputation and life. If let's say the government does decide to take the case, it becomes public. They get a whistleblower award, but at the same time, there's professional risk, their name gets out there. So what happens then to the whistleblowers who, let's say, complain to us, but we decide not to proceed? Are they taking that risk? And the answer, I would argue, should be no, as it is under the SEC program, where those submissions, a whistleblower submission, remains confidential and non-public, such that if we do not specially designate it, if we do not proceed, that whistleblower is not subject to public disclosure. And that's a really important part because there is, especially a current employee, you can imagine the risk that they might have to take in bringing allegations to a government authority, that the professional implications of that. So that aspect of confidentiality is important in the SEC program. It would be important for us. It does not work that way under all laws. So the SEC program works that way, but in False Claims Act cases, for example, by the Department of Justice, those whistleblowers, when they file a submission there and the government declines, the default is that becomes public. But that's because that whole whistleblower program for the Department of Justice and the False Claims Act is a totally different animal. It's one that actually involves what is akin to a private right of action if the government declines. And that's not what Ms. Mahoney described.
And the SEC whistleblower program, forgive me, it doesn't have a key time component either. It's
correct. It's not
Correct.
a key TAM provision.
right. Okay. I think you answered my question about the information gathering and the investigation in the course of answering Ms. Hamer and Mr. McTaggart's question. Please, of course, feel free to expand, but I wanted to give Mr. Liebert a chance to ask his question.
Sure, thank you. We're very lucky, obviously, to have your experience personally in your career in this whole area. So that's very encouraging to have that level of expertise. I think it's a terrific idea. Many of us will remember Frances Haugen at Facebook serving as a whistleblower, and the information that she revealed about the dangers to teenage girls was so critically important, and hopefully led to some improvements within the organization on that issue. I hope so. It obviously, the whistleblower approach is designed ultimately to be a good incentive structure for corporate players to do well, right, and to have good conduct. So I think that would be very exciting. It also probably reflects that this is a potentially difficult political lift. No one wants to get whistleblown, I'm sure of that. So I wanted to ask you how this might compare, Mike, to the SB 53 provisions on whistleblowers that was just enacted into law. And if you don't know that, that's okay. But I do think that that's an important question for us to make sure in terms of compatibility and what the governor obviously ultimately has helped sign into law, that type of approach.
Before I address that, I'm going to turn it to Ms. Mahoney to see if you have a reaction first to the 53 component.
Yes, absolutely. So we're definitely giving a close look to SB 53. I think there would be differences between that and this proposal. SB 53 is focused on anti-retaliation provisions and then providing some sort of process for internal reporting. I think our situation is different in that, we already have the CCPA and the agency to address some of the reporting questions. And then where this proposal would go a step further is providing incentives for whistleblowers to come forward by allowing them to share in the proceeds of a successful case. So this would go a step further, but we think it's important because of the risk that whistleblowers are facing. It's not enough to just say, well, if something happens to you, there are steps you can take. This would be providing more incentives to come forward upfront.
Thank you.
I agree with all that. And I would say that one of the things we've tried to do as a newer agency is take the best pieces of other agencies, even if they're from different spots, and put them together for us. And this isn't, I think, a really good example of that, where what we're envisioning, at least for this program, is to take aspects of the SEC program, aspects of the DOJ program, maybe aspects of others, but to get one that fits for privacy, that's good for consumers, and Board Member Liebert, that speaks to what could otherwise be a significant lift, make it into something it really shouldn't be.
And the funds, sorry, just remind, the funds, to the extent that there is a whistleblower action, are there funds involved that will then come back to enforcement needs?
The funds would, under our law, go to the Consumer Privacy Fund. There would be then a sharing under this concept with the whistleblower. The idea here is to create a net positive. In other words, in any one given case, we would collect less, for example, in the fines. But the whole point here is to have a larger number of those cases that come with special evidence, heightened evidence, and collaboration with the whistleblower attorney that should allow us to do more of them, creating an overall net positive.
Thank you. Ms. Hamer?
Yeah, so I support this as well. I think that whistleblowers are going to have information as to any kind of intent going on with data processing activities from the internal side that can't be gleaned from a website. It's like, oh, I didn't get my do not share or do not sell my personal information button. Do you have thoughts around the sharing, like how much goes to the whistleblower? I just, having come from the corporate world, that's a big ask for somebody to come forward like that and a big risk. So what are your thoughts about the revenue sharing on that? And I like the protections, the anti-retaliation provisions are key on that.
I agree completely that anti-retaliation is kind of a foundation upon which we could build something bigger with this program. And as for the amount of sharing, the whistleblower laws that exist, and there are many across a lot of different subject matters, typically involve some percentage sliding scale. And I think what exactly those percentages would be is something we would have to come up with some proposals for consideration. But that's something, that amount, it should ultimately be a range that we could set depending on the degree and nature of the evidence, the degree and nature of the cooperation and collaboration that we received. So in most of these whistleblower cases, at least the ones that I've done, when you get to the stage that a case has resolved or been litigated and there is an amount of money, there's then an analysis that gets done of how significant was the whistleblower's contribution. And it inherently recognizes the risk that whistleblower takes. I think we mitigate that risk here somewhat compared to other whistleblower cases because the public disclosure could come only in cases that we specially designate. So in other words, if the whistleblower rolls the dice, makes the submission, and we determine actually that's not the right case for whatever reason, the risk is gone. So the risk comes into play then only at the stage where the whistleblower is set to receive money. And I agree completely that as a policy matter, we would want it to be enough to compensate a whistleblower for the risk. And I think the amount of that is something that's a tougher policy decision that's going to have to be made.
That makes sense, total sense. I also see an added benefit that businesses, if this is out there, businesses might be making better decisions going forward, as opposed to, you said, rolling the dice. So, you know, the agency may or may not come after me, so I'm going to do what I want. But I think if they have the knowledge that somebody inside could kind of pull back the curtain, then that's an added benefit.
I think that's right. And most of these laws they're written in a way that still encourages and protects businesses from reviewing their compliance and kind of trying to get to the right decision and do the right thing. The way these laws are normally written, it's to provide a way for whistleblowers to raise allegations of noncompliance where the company is doing the wrong thing. And so that gets kind of into the weeds of how these get written, but our proposal, the concept here is to take that into account so that we can still incentivize businesses to invest in compliance, do the right thing on their own. And if they decide not to, have some mechanism as a backstop to provide reporting to our agency that goes beyond what you'd see in a consumer complaint.
Right, I agree. Well, I think it's a great idea, and I think it's a heavy lift. So thank you for being willing to take it on.
Thank you. Before we move to Ms. Mahoney's presentation of the other two bills, which are simpler in their operation, I wanted to pause to just give the board some notice that when we get to the end of the discussion, I believe Ms. Mahoney is going to ask us if we will support staff working up through sponsorship or possibly another model for each bill. So with regards to the bills, I would like you to think about whether there are broad features that would be showstoppers for you or would be requirements for you. Obviously, we don't know what the bill would look like, what a sponsor might want to put into it yet. So I don't mean to overly constrain Ms. Mahoney or staff, but simply to provide guidance about some of the things that might be, fundamental components of a bill. I think the whistleblower bill is a good example of this. I, for example, want to be sure that those anti-retaliation protections are there. I think the confidentiality guarantee, regardless of whether or not the claim is taken up by the agency, is really important for the same reason. I trust that in negotiation with sponsor and experts and staff, they can figure out the percentage compensation to make it attractive and also to compensate for the risk. So just to give you some examples of the kinds of things that I'm thinking about, it wouldn't necessarily mean, I think, that we wouldn't support the bill when you came back, but it would give you guidance for helping to craft things with sponsors should you find them. So I'd like the board to think about that. I don't want to put you on the spot this second. So if we could continue with the right to delete bill and talk about that. Thank you.
So the second proposal, so we propose to extend the right to delete to cover all personal information collected about a consumer. I think a lot of people probably think that's already in the CCPA, but currently the CCPA only requires a business to delete personal information that's collected from the consumer, which means that it does not have to delete personal information collected from a third party. And as you know, businesses today routinely purchase additional information about consumers to supplement the data they collect directly. Requiring only the information collected from the consumer to be deleted could create a false sense of protection for consumers. Most other states with comprehensive privacy laws apply the right to deletion to all information collected from a consumer. I believe it's only Iowa and Utah that do not. The Delete Act also provides important precedent in the sense that under that law, all information collected about a consumer would have to be deleted, provided it's not exempt. But the Delete Act applies, as you know, only to data brokers. So we think it's time for the CCPA to have a right to delete for all personal information collected about a consumer. So that is the right to delete.
Wonderful. Ms. Hamer?
Yeah, this is just a quick question. It might be a silly question, but besides data brokers, what other third-party, I have some things in my head, but what other third-party data sources are we thinking about?
Great. So yeah, this bill would provide protections with respect to businesses that are buying information or collecting information from other sources, not necessarily from the consumer, but are not necessarily selling that information on to a third party. So you could see a situation where a retailer is using information collected from a consumer, but they're also collecting demographic data about a consumer or browsing history or purchase history from other companies and combining all of that into a profile and then using that to target consumers for advertisements more precisely. So some consumers may want that, but others may want the opportunity to have all of that information deleted.
Understood. I mean, the concept makes total sense. In my brain, behind my question was the business operationalization of that. You know, businesses are still somewhat siloed, so it will force them to have one single source of truth per consumer. So that might take a little bit of runway for them, but
Okay.
I think, you know, in my mind, what's the easiest way to get this done? Just say, you know, all information from or about consumers.
Mhm. And you would know better than I, Ms. Hamer, but I do think that also some companies do not have that differentiation. And so figuring out what has been collected directly could also be a challenge.
That's my point.
Yeah, yes, exactly. This means you can go for the consumer in the data lake and pull them out instead of trying to figure out which bits of information in the data lake need to be pulled out. I'm interested that so many other states already have the more general right to delete, which is of course another source of requirement for businesses to have a better sense of the connections between the source of the data, and the consumer. Mr. Liebert, did you have your hand up?
Yeah, that's an excellent point. It seems like this might be one area where the CPPA actually was behind the 8 ball in a way compared to what other states are doing. And it's obviously logical to have that more expansive approach. So I'm wondering how big a lift this one is too, because we're obviously bringing in a lot of additional companies, right, that right now might not be affected. And so you gave kind of a general example of retailers, but I guess some sort of political sense as to how big a lift this is for the staff and in the process.
That's a good question. You know, I think this bill would have a significant impact for California's consumer privacy. So I don't want to minimize it in any way. And part of the reason why we are bringing this forward is to start getting that feedback from businesses. And, you know, we're still at the very early stages of that. You know, I do think the fact that, as Chair Urban pointed out, most other states have this broader requirement should make it an easier lift for businesses. So I think ultimately it's difficult to tell at this time what the political lift will be, but we want to start the conversation.
Well, I know we're not saying yet till the end as to our support or op, but this is another one that I think is an excellent idea and shows great thinking on the part of the staff. Thank you.
Thank you, Mr. Liebert. Shall we move on to the last suggestion?
Great. And the final one, we recommend that the CCPA require alternative methods for submitting consumer requests. So currently, online-only businesses that have a direct relationship with a consumer are only required to provide an email address for collecting access, deletion, and correction requests. Opt-out is a different process. So we think just this email only creates a barrier because it gives consumers little support or guidance. We think that alternatives like web forms would be more consumer friendly, would take less time for consumers because they would have more information about what to input and be less chance that they would have to follow up. The feedback that we've heard is that it's not always easy to submit consumer requests and protect their privacy online, and we think this would help close some important gaps. And that concludes my presentation. I welcome your feedback.
Thank you. I think it's an interesting question as to what the alternative methods would be. I'm certainly very willing for staff with expertise from the legislature and maybe other partners to consider what would be the appropriate paths. I'm very supportive of this in my other life and in another area of law. I did a fair amount of empirical research into notice and takedown under the Digital Millennium Copyright Act, and I have looked at a lot of notices sent in a lot of forms, and there's a two-sided challenge here when you have something that is an email address for a request like this. One challenge is absolutely on the consumer side, being able to understand what to do, where to send. They would have an email address, of course, possibly having access to the right systems to do that. Most people, of course, use email now, but not everybody. They also have a challenge as to how to formulate the request. And that brings me to the other side, the other side of the two-sided challenge, which is when you're asking somebody who isn't an attorney, who isn't somebody who's embedded in that business, to make a request that is exercising a right like this, it is very difficult for the request to contain the necessary information, frankly. So I think that, I spent a lot of time parsing notices, and I had a postdoc who was brilliant at figuring out what people meant and understanding what they were requesting. That is not efficient for the company, and obviously that isn't going to vindicate the consumer's rights. So I'm very supportive of this, and I will be interested ultimately in what is the path that will be efficient for both parties. Other comments or questions on this one? Yes, Ms. Hamer.
I also think this is a great idea. So there are 3 here, and I was just curious about other areas that other states might be more strong than CCPA. You mentioned Maryland had a couple of provisions in their bill that were stronger. So did you consider other possible areas for us to proceed and then reject them, or tell me the thought process on how you came up with these 3?
Sure, absolutely. So we did come up with a longer list of about a half dozen proposals, primarily looking to other states and where they set a higher standard. And then we did preview these ideas with key stakeholders in the legislature, the Attorney General's office, to get some high level input. And, I think all of the ideas were generally positively received, but I think it became clear that some of them needed additional thinking through. So an example for that would be expanding the CCPA to cover nonprofits. We wanted to give that one a little bit more thought and have the opportunity to explore stakeholders' positions before moving forward with that. So I would say that the 3 that we're moving forward with are good, and that they're different kind of levels of proposals that might provide good variety for legislators to continue, and ideas that we generally got positive feedback about.
Okay, thank you. I think it's a good list. So thanks for the work behind it.
Thank you, Ms. Hamer. Mr. Liebert?
I recall along the way that we've talked about the penalties that exist right now for the drop system if people aren't appropriately signing up, registering. And it seemed like they might not be sufficiently adequate, but it was a timing issue. I might be throwing this at you, Mr. Laird. Was there consideration as to at what point perhaps there should be consideration about those penalty levels?
Yeah, great.
I'm happy to take that one. Thank you. So certainly that is something we continue to think about, is just ensuring that enforcement is truly encouraging compliance, and that penalties encourage compliance as well. I think what you're referring to is penalties with respect to failure to register, which have been set at $200 per day each day a data broker is late. I think the difference is that beginning in 2026, when the drop system comes online that we were discussing, a business's failure to register will not just be its failure to register. It will also be its failure to delete requests coming through that system. I did not do this math. Our attorney, Liz Allen, did this math for me because I'm not a mathematician up here. But we calculated roughly that if 100,000 Californians make drop requests in this system and a business fails to register for a year and does not process those requests, we're looking at approximately $7.3 billion in fines. So what I think maybe historically was an issue, at least with the Delete Act framework, is sort of disappearing as a result of those heightened fines with this new program coming online.
So the mechanism will be discovering then through the enforcement process that a particular entity is not honoring those requests.
Yeah, and happy to go into detail about this now or during that item, but essentially a registered data broker may be telling us they're processing those requests and they're not. That would be grounds for a fine. But what I'm trying to communicate to is a data broker who has never come into our purview and has never registered like they should have. If they take a whole year starting in 2026 to fail to do that, they've not just accrued the fine for failure to register, they've accrued for failure to delete. And that's $200 per day per consumer request.
How do you count the consumers if they're not on the drop system to request delete from? Or maybe we should talk about this under that agenda item, but now I'm really curious.
Well, I'll answer that specifically, and you will see in the system later. One of the selection options when you register
all data brokers
is all data
and you
brokers,
count the
including
people who
future
chose.
data brokers.
Sorry, I'm talking over you. Yes, okay, yeah. So you have the people who chose all data brokers. That is a strong indication that their motivation was all data brokers and that they intended all data brokers, including the data brokers who are invisible. There's no reason to think that they would have wanted to carve out one of the invisible data brokers. So one can count the all data broker choosing people and know how many violations the invisible data broker has done.
That's correct. And to your point, it's automated in the extent that if that data broker did come in just a month later and register, they'll automatically then receive a deletion request from that consumer who had checked the all data brokers box.
Great, thank you. Other comments or questions on the last item or other items? All right, I'm going to go ahead and preview the motion that I'm considering. I haven't heard specific parameters exactly. So I think that one option for a motion would be to direct the staff to pursue the legislative proposals described today by Ms. Mahoney with the California Legislature for the upcoming session, and to allow staff flexibility to support the proposals up through a sponsorship capacity, which she's explained to us, based on staff's assessment of the level of support and the features that will give the proposals the greatest chance of passage and the greatest effect, with attention to the parameters discussed by the board today. So I added that bit at the end to provide our guidance, but not necessarily to hamstring anything in particular, given that we don't know exactly what the bills would look like yet. Does that make sense to you, Ms. Mahoney?
Yes, it does.
Okay, wonderful. Is there public comment on this item?
Okay, this is for agenda item number 2, legislation update and agency proposals. If you'd like to make a comment at this time, please raise your hand using the raised hand feature or by pressing *9 if you're joining us by phone. Again, this is for agenda item number 2. I have Matt Schwartz. I'm going to unmute you at this time. You'll have 2 minutes, or I apologize, 3 minutes. Go ahead and begin when you're ready.
Good afternoon. My name is Matt Schwartz. I'm a policy analyst at Consumer Reports. Thank you for the opportunity to speak, and thanks for all of the agency's critical work to advance consumer data privacy legislation. While we look forward to following how all of these proposals are honed into more concrete legislative text, Consumer Reports does support all 3 of staff's proposals in concept. as we believe they will improve the agency's ability to carry out its oversight functions that protect consumers in California. Just yesterday, we were provided with a clear example of how internal whistleblowers can provide the public and enforcers with critical information about the wrongdoing of powerful companies that we would never have seen otherwise. A whistleblower at Meta revealed to Reuters internal documents that established that Meta makes a staggering 10% of its annual revenue from advertisements it highly suspects to be scams or fraudulent, and that executives at the highest levels of the company were aware of these facts and failed to reduce such scams for profit-motivated reasons. This is exactly the type of information that the public deserves to know, but too often, company operations and data processing activities are a black box that are impossible to assess from the outside. And the reality is that many employees either lack motivation or are too scared to reveal illegal behavior. This proposal will address these hurdles by financially incentivizing employees and protecting them from retaliation. That should help insiders share information with enforcers that will help protect every Californian's privacy. We're also supportive of the proposal to bring California's deletion right in line with that of most other state privacy laws, which do allow consumers to delete all of the information collected about them by companies, not just the data collected directly from them. To many consumers wanting to delete their data from a company, the sources of the information are likely irrelevant. And if anything, personal data about them sourced from third parties is more likely to be objectionable. The current deletion right likely contradicts their expectation of what a deletion request will accomplish, and it should be strengthened. Finally, we agree with staff's proposal to require online-only businesses to provide multiple opt-out mechanisms. Privacy rights should be easy to exercise, and well-designed web forms are much easier for the average consumer to complete than an open-ended email request, which in practice often requires multiple back and forths to fully resolve. Thanks again so much for the time and for your consideration of our views.
Thank you so much. Katarina Fitzgerald, I'm going to unmute you at this time. You'll have 3 minutes. Go ahead and begin when you're ready.
Thank you, Chair Urban, members of the board. My name is Katrina Fitzgerald, and I'm Deputy Director at the Electronic Privacy Information Center, or EPIC. EPIC is a DC-based independent nonprofit that was founded over 30 years ago to secure the fundamental right to privacy in the digital age. And in my role at EPIC, I work with state legislators across the country to advance strong privacy legislation. I just want to say that EPIC really appreciates the impact California's leadership has had on state policy nationwide. EPIC comments today to urge the board to approve the proposals for legislation outlined in the memo from agency staff and in the presentation today. First, a bill to establish comprehensive whistleblower protections, a really common sense addition to the CCPA. As the memo notes, data abuses often happen outside the view of consumers and even of investigators and enforcers. And in EPIC's work at the federal level, we've heard from multiple sources, including within the industry, that the lack of robust protections and awards for whistleblowers at the Federal Trade Commission makes it very hard for the FTC to secure industry whistleblowers the way the Securities and Exchange Commission does, because it has strong whistleblower protections and an award system. As talked about, whistleblowers take huge risks when they step forward, but their willingness to do so can have a massive impact on Cal Privacy's ability to stop harmful business practices. So EPIC urges the board to approve this proposal. EPIC also supports the proposal to extend the right to delete to cover all personal information about the consumer. This is a rare area where the CCPA provides a weaker consumer right than the vast majority of the 18 other states that have privacy laws. And it makes sense to update California's law to allow consumers to request to delete all personal information a business holds about them, not only information that the business collected directly from the consumer. Lastly, EPIC supports the proposal to require businesses to provide alternative methods for submitting consumer privacy requests. We've seen in the years since the CCPA was enacted that businesses will make it as difficult as possible to exercise privacy rights. They're only going to provide the bare minimum that they're required to by law. and requiring consumers to exercise their privacy rights by saying in an email just it doesn't make sense in 2025, right? When I think about whether a privacy right is usable, I always like to think, would my mother in her 70s be able to do this? And she'd have no idea what to send in an email to a company to exercise her privacy rights, but she would be able to fill out an online form that prompted her for the info the business needs to exercise the request. All three of these proposals would help California continue to be a leader on privacy, and they do so with little added compliance burden on companies. So EPIC respectfully asks the board to approve these proposals. Thank you.
Thank you. Robert Boykin, I'm going to unmute you at this time. You'll have 3 minutes. Go ahead and begin when you're ready.
Okay. Good morning, board members. My name is Robert Boykin, and I'm here on behalf of TechNet, representing more than 100 companies across the innovation economy. While we appreciate your continued work to strengthen privacy in California, we urge the board to proceed carefully before advancing new legislative or rulemaking proposals. Regarding whistleblower protections, California already has comprehensive laws. The burden should be on demonstrating that the existing statute wouldn't protect someone reporting here. Creating bespoke, topic-specific whistleblower systems adds unnecessary burdens for businesses. As you discussed earlier, the legislature recently passed and the governor signed SB 53. While we disagree that a specific frontier model whistleblower rule was needed, given the range of existing whistleblower protections in law, SB 53's narrow focus on extraordinary risk, such as mass casualties and weapons of mass destruction, is very different from CCPA violations, which, while serious, don't pose a catastrophic risk. Regarding consumer request methods, businesses vary widely in terms of size and structure. They require flexibility to design efficient and secure systems that align with their broader compliance frameworks. A one-size-fits-all approach could create unnecessary friction for both consumers and businesses, while a flexible approach would ensure accessibility, efficiency, and data security. Finally, with respect to additional rulemakings in general, we ask the board to consider significant compliance investments already required under recently finalized regulations. Over the next several years, businesses will be devoting substantial resources to implementing the agency's new rules on risk assessments, automated decision-making technology, and cybersecurity audits, along with amendments to existing CCPA regulations. We urge you to allow businesses the time and bandwidth to come into compliance with these new obligations before embarking on additional rulemakings. In closing, TechNet encourages the agency to maintain a focus on balance, transparency, and workability. Thoughtful, evidence-based policymaking will ensure California continues to lead on both privacy protection and responsible innovation. Thank you for your time and consideration today.
Thank you. Alicia McDonald, I'm going to unmute you at this time. You'll have 3 minutes. Go ahead and begin when you're ready.
Thank you so much. Hi, I'm Alicia McDonald of Vela Strategies. I love the proposals we've heard today. For web forms, I would like to encourage you to go one step further. In addition to people filling out a form with their names and other PII, please consider that many companies do not hold names and PII on purpose, and yet they can in fact re-identify people. So companies will answer when they receive an opt-out that they hold nothing about Jane Smith, while they continue to use a GUID and a cookie or other tracking technologies to uniquely identify and target Jane Smith. Therefore, I hope you'll consider adding to the web form a path that companies will read their own identifiers, their own trackers, and use that in identification as well as the user-provided, the consumer-provided PII. Secondarily, we hear that many consumers are very concerned about having to provide PII to exercise their privacy rights. So I would like you to consider having a web form where people do not provide new information. They simply are opted out, deleted, anything else that we're going to do with the web form on the basis of how the companies themselves identify those consumers. I think that will give a much stronger and more trustable path for people to be able to go through. Those who wish to provide their names, their phone numbers for things with data append, for example, should absolutely be able to. But for those who wish not to provide new information to delete what's there, I think this is a really crucial part of how things move forward. So I would like you to consider not just a web form as an easier type of email, but also as an ability to use the types of technologies companies already have in place to actually make this a fully realized set of privacy rights. Thank you so much for your work. It's exciting to see what you're doing.
Thank you. If there are any other members of the public who would like to make a comment at this time on agenda item number 2, legislation update and agency proposals, please go ahead and raise your hand using Zoom's raised hand feature or by pressing *6 if you're joining us by phone. Again, this is for agenda item number 2. Madam Chair, I'm not seeing any additional hands at this time.
Thank you, Ms. Carwile, and thank you to all the commenters whose thoughts are very helpful and appreciated. With that, I would like to request a motion to direct staff to pursue the legislative proposals described today by Ms. Mahoney with the California Legislature in the upcoming session, and to allow staff flexibility to support the proposals through a sponsorship capacity based on staff's assessment of the level of support and the features that will give the proposals the greatest chance of passage and the greatest effect, with attention to the parameters and preferences discussed by the board today. May I have that motion? I have a motion from Ms. Hamer. May I have a second? I have a second from Mr. Liebert, and Mr. McTaggart's hand is up.
Okay, I give it to Mr. Taggart.
Anyway, we have a motion and a second. And Mr. McTaggart, before though we move on, do you have your hand up with regards to the motion or for further comment?
Thank you. I was willing to do both, but I'd like to just make one comment, which, and I know we're not supposed to, and Chair, you can keep me on the straight and narrow here about the rules. I know we're not supposed to comment on comments that were brought up. I just wanted to point out that, I have for a long time sort of separately and fully agree with Ms. McDonald's comments. She happens to be a national expert in this area, academic and otherwise. And I really do believe that there should be, as we go forward, a button. If you don't want to give your email address, you want to opt out, and you want to basically say to the company, anything you know about me, however you identify me, I want you now to delete. And I think that's almost a more powerful kind of way to go back to the company, because they do obfuscate and they do hide how they know about you. And so if they're fingerprinting you and you say, look, now you got to delete all that, that to me is way more powerful. And I really echo that. So as we go forward, on the opt-out, that's one of my real priorities. Thank you. And yes, I do support the motion.
Thank you, Mr. McTaggart. I think Mr. Liebert will be the one to keep us on the straight and narrow. I think we can comment on the comments in our discussion. I also value Dr. McDonald's comment, and I think it's really important to know that she's been really deep in the weeds of the research for many years about how these systems actually work. So I have a motion and a second on the table. Ms. Carwile, would you please call the vote?
This is a roll call for the motion as stated by the chair. Board Member Hamer?
Aye.
Board Member Liebert?
Aye.
Board Member McTaggart?
Aye.
Chair Urban?
Aye.
You have 4 ayes.
Thank you, Ms. Carwile. The motion carries with a vote of 4-0. Ms. Mahoney, thank you very much. Mr. Macco, thank you very much. And we will look forward to hearing how things develop, probably May-ish, I think. Wonderful. Thank you, Mr. Liebert.
I just want to note, maybe I was the only one who noticed this, but I think we'd have to look back in our records. But Katrona Fitzgerald's from EPIC referred to Cal Privacy. And I think that might have been the first time we've had someone on the line saying Cal Privacy. And I'm just excited about that. I think that's a great development. I think Californians are going to understand what we do a little bit better.
Thanks, Mr. Liebert. All right, moving on to agenda item number 3, the annual intergovernmental affairs update and priorities. This will also be presented by Deputy Director of Policy and Legislation, Maureen Mahoney. It covers, please turn your attention to the materials provided for this agenda item. And I believe Ms. Mahoney is planning to present these slides all together and then pause for discussion at the end. So please go ahead.
Great. So today we are proud to share the progress that the agency has made in developing partnerships across the globe and look forward to the board's input and feedback on priorities for next year. And I just want to emphasize that this is by no means just the policy and legislation team. This work brings together everyone, admin, enforcement, the exec team, IT, legal, and public affairs in developing these partnerships. Next slide, please. There's an enormous amount of work being done in the privacy space, and our mission is to identify engagements that are the best use of agency resources. We don't want to be everything everywhere all at once. We want to be everywhere strategically all at once. So to that end, there are a few guiding principles for our engagement. So first, we select engagements that will advance education and awareness about California's privacy rights and protections. Second, we choose to engage when it's necessary to protect Californians' privacy rights. So that could include enforcement partnerships or policy pushing back on preemption efforts. Third, we have a statutory mandate, as I mentioned several times, to ensure consistency among privacy laws. So where we see opportunities to shape policy, we want to be engaged to be able to share California's approach and why we took that approach. And finally, we recognize that there are issues that are best approached as a collective rather than as a standalone. So that could be through enforcement, public awareness, or policy. And these are the principles we use to prioritize our engagements. Next slide, please. So first, looking at California, we're really proud of the relationships, partnerships we've developed. The California Attorney General obviously is a natural partner. We share enforcement of the CCPA and a commitment to protecting Californians' consumer privacy. We're in frequent communication, work closely on enforcement and policy matters. For example, the enforcement team recently partnered with the California Attorney General and other attorneys general on a multi-state investigative sweep of compliance with the global privacy control. I'll talk about that a little bit more. We also worked with the Attorney General's office in California to push back against preemption efforts, and again, very much appreciate the California Attorney General's support of the California Opt-Me-Out Act. Likewise, the California Civil Rights Department is a natural partner. They, like us, were working on a rulemaking having to do with automated decision systems. They finalized theirs in spring of this year. So we engaged with them to help ensure consistency among our laws. We're also enormously grateful right now for the partnership with the California Department of Technology, for their dedication and generosity in working with us to develop the DROP system under the DELETE Act, which will be discussed more later. The Department of Insurance has been another important partner. Recently, the legal team worked with them on the insurance regulations that were recently finalized, and we've been supportive of their work of SB 354, the bill that would regulate insurance company data processing practices that we anticipate will come back next year. And as Megan mentioned in September, we with Public Affairs in the Lead recently teamed up with the Contractor State Licensing Board and the Department of Financial Protection and Innovation to do some outreach across California, specifically targeted to older Americans, to help them understand their rights under the CCPA and exercise those. For example, the agency did senior scammer events at town halls that were hosted by Senators Ashby and Wahab, Assembly members Berman and Stephanie, and those are all separate events, as well as before the Assembly Democratic Caucus. And then we have separate events with Senator Becker and Assembly members Pacheco and Rodriguez in the coming months, and still more to come. So these events are great opportunities to do direct outreach to community members, partner with other state agencies, and deepen our relationships with legislators. Next slide, please. And with respect to multi-state engagement, we've continued to engage to continue to encourage consistency in privacy protections as more states consider privacy, ADMT, and DELETE style laws. We're delighted this year that Cal Privacy joined with 9 other state privacy enforcers to form the bipartisan consortium of privacy regulators. This group will continue to collaborate on enforcement and implementation of their privacy laws. And from a policy perspective, already this year, the consortium worked together. Some members joining our letter to oppose the 10-year AI moratorium on the federal level. And we also continue to participate in bipartisan multi-state AI working group, and this is spearheaded by the author or the sponsor of the Connecticut Privacy Law. It's now facilitated by the Princeton Center for Information Technology Policy. That meets roughly biweekly. It comprises legislators from across the country to discuss how to better achieve consistency across states, particularly in the AI and ADMT space. And finally, as I mentioned earlier, in September, the Enforcement Division announced an investigative sweep that it's doing along with the Attorneys General of California, Colorado, and Connecticut, focused on business compliance with the global privacy control and opt-out preference signal. I thank them for their work on that, and it's well-timed to ensure that Californians' rights are protected in advance of the California Opt-Me-Out Act becoming effective. Next slide, please. Let's see, moving to international partnerships. So this is developing these partnerships is another important aspect of our work. They're critical for enforcement collaboration, again, in ensuring consistency and spreading awareness of Californians' rights. So first, I want to highlight some global privacy organizations that we are a part of. So these are bodies that bring together data protection authorities from around the world to share information, to collaborate, establish standards. So we've been first a member of the Global Privacy Assembly for about 4 years. This is probably the biggest organization in this space, brings together about 100 data protection authorities from across the world to share information, coordinate on privacy. Unfortunately, we were unable to attend the annual meeting this fall in Korea due to statewide budget constraints, but we're very pleased that the Enforcement Division was shortlisted for a GPA award in the dispute resolution and enforcement category for their investigative sweep on data broker registration compliance. We're also members of the Asia Pacific Privacy Authorities, and that's a similar organization focusing on data protection authorities in the Pacific Rim. So our engagement with this body has led to some important collaborations, which I'll get to in a moment. And then finally, we're members of the Berlin Group, also bringing together DPAs, but in addition, a lot of privacy experts, and there's a focus on privacy enhancing technologies. Similarly, the agency, next, I want to highlight some partnerships that were formed over the past year, and these have really improved our ability to work with other jurisdictions and improve consistency around the world. As I just mentioned, our involvement in the Asia Pacific Privacy Authorities and our attendance at their meeting last year allowed staff to develop closer relationships, leading to the Declaration of Cooperation with the Korean Personal Information Protection Commission. And this declaration establishes a general framework of cooperation to share best practices, share annual enforcement plans, and convene periodic meetings among staff. Similarly, we also signed a declaration of cooperation with the UK's Information Commissioner's Office. That also allows us to collaborate on joint research, share best practices, and develop mechanisms for collaboration in convening meetings. And then finally, we were very fortunate to have 2 Humphrey Fellows, a State Department program, in residence with us in Sacramento for 2 days this year. We had fellows from the Irish Data Protection Commission and the Australian Department for Home Affairs. This was a unique opportunity to share knowledge and strengthen relationships. And then just last week, we announced that our Enforcement Division was participating in a sweep with 30 other regulators through the Global Privacy Enforcement Network. And that involves a review of websites and apps that use children's data. And we coordinated the sweep with regulators worldwide. Next slide, please. So on to some other highlights for international engagement. We're very fortunate to be the lead author of a Berlin Group working paper on opt-out preference signals. We've been working on it for about 1.5 years now, and it's close to being done. We worked with an international team of Berlin Group members to draft the paper that explores how these signals can be used and potentially interpreted across jurisdictions. The final paper will be presented in Uruguay later this month by one of our drafting group partners for formal adoption by the body. Similarly, the agency was involved in an international roundtable on consent practices hosted by the Organization for Economic Cooperation and Development, or OECD, and staff gave a virtual panel presentation on opt-out preference signals to a global audience of policymakers. And we continued to be active members in the Asia Pacific Privacy Authorities. We attended the summer convening by video conference. It was a fully virtual meeting, and they're having their fall meeting later this month in Macau. That'll be hybrid, and we'll be participating remotely. So those are a great way to spread awareness about the agency's ongoing initiatives. And finally, throughout the year, staff met for in-person bilateral meetings with global data protection authorities. These are often meetings entities we have agreements with France, Korea, and the UK. And then finally, looking ahead to 2026. So apologies, I don't have a slide for this, but I did want to open a discussion about next year.
Actually,
Yes,
could
right.
we hold that
Okay.
for just a moment? So that the board can comment on the report from the last year and the overall development. I'm going to take chair's prerogative and go first, which I usually do not. But I think since I've been on the board longer than anybody else, I'm well placed to make the comment that I want to make, which is the extraordinary nature of this achievement for the agency. You all have heard me quote this many times. I'm going to do it again, which is quote the portion of the CCPA that Ms. Mahoney alluded to. We are charged with cooperating with other agencies with jurisdiction over privacy laws and with data processing authorities in California, other states, territories, and countries to ensure the consistent application of privacy protections. This is one of my absolute favorite provisions in a law that has a lot of favorite provisions for me. And the reason why is because of its vision and its practicality both. Data flows do not exist in ways that are amenable to jurisdiction by one agency within a state. Data flows exist across industries today, and they exist across different areas of jurisdiction for California agencies. Data flows do not exist only within California, nor do they exist only within the United States. Therefore, providing rationalized, meaningful privacy protections to people who live in any part of the world is to some degree dependent on the actors in the other part of the world, and providing rationalized protections that businesses can implement similarly. It's very helpful to have harmonization that does take into account local requirements and conditions, of course, and what is necessary for any jurisdiction to protect its people and balance protections for its own businesses and other actors. But what you need is a net, and the net needs to have a fairly tight weave. There is no way to have that net have a tight weave without this kind of cooperation. What you have managed to build, and I give also credit to our first executive director, Mr. Sultani, who worked on this tirelessly. What you have managed to build, I won't say it is beyond my dreams and hopes, because I have very, very large dreams and hopes, but it is certainly more than I expected in terms of where we would be able to be at this point in our development. And it speaks to the careful attention to building these relationships. It also very much speaks to the quality of the work that the staff is doing and the far-reaching vision that they have had for how to think about these connections and how to, as Mr. Macko said earlier, in the context of whistleblower laws, consider what's working in other places, consider what would be beneficial for Californians, consider where we can share, where we have been ahead. and to do that. I'm just beyond impressed with what you've accomplished. I also want to note how crucially important this net is at this time when we have a federal government that is not a good partner, and that I believe is putting it mildly, for California and for protecting Californians. The activities of the federal government with regards to the personal data of Americans and the decisions that it has been making constitute a situation which means that states and their ability to step up and to cooperate are even more crucially important than they would have been anyway. And I really commend the staff for building these relationships at this moment in particular. I know you didn't mention it. I am saying this from my perspective as the chair, that I think that at this moment in particular, these efforts are crucially important, and I appreciate them tremendously. I think I appreciate them on behalf of Californians, and I believe that other jurisdictions also appreciate these kinds of cooperation. So thank you, and I'm impressed and grateful. Ms. Hamer?
I'm just going to say she's a tough act to follow, but I agree with everything she just said.
Thank you. Mr. McTaggart?
Thanks. Can we just get a little update on adequacy and GDPR? Where we might be thinking about there?
Yes, thank you for bringing that up. Staff have had discussions with officials in Europe about potentially providing a presentation before the board to answer any questions that they might have about adequacy, and could go into better detail. And then staff is also working to do the legal research to analyze all aspects of that as well. So we're definitely working on it. It's on the list, and we hope to have more information at a future board meeting.
Thank you. Mr. McTaggart, would you like to talk about timing more? We could also talk about it under the future agenda items, just so staff have a sense of your sense of timing, unless you're happy with that.
No, I mean, obviously there's more opportunity than there are resources, and I'm very impressed with the steps that the team has made and taken, and I just think it's sort of and not or. I know that what I would hope is that if we can start discussions with GDPR, with Europe, with a sense of what is missing, if anything, in the California law, so that we could be moving towards an adequacy determination. I think that would be, it's always been my goal, and writing the thing this is always sort of the end goal, was to get an adequacy determination, because GDPR, as everybody knows, allows for territories, not just countries. And so I think that would be very, very, that's the end goal, because if we can do that and get an adequacy determination, then I think business will flock to our standards, because why wouldn't you? Then you have, such a big portion of the planet covered with one sort of set of regulations, and then that smooths out the transatlantic data flows. Just would have a tremendous benefit for consumers and businesses, for everybody. So that's my goal. And because we've been successful, look at 566. The team has been successful with amendments. If there are amendments necessary, if Europeans came along and said, okay, this is great, but you need this one thing, there's potential that we could start working on that in the legislature. So I'm not telling anybody on the team anything they don't know. So I just was looking for an update on that and the timing. So thanks. Thank
you, Mr. McTaggart. Other comments on the update before we move? Sorry, apologies, my mic cut out. Any other comments on the update before we move to the 2026 plans? No. All right, please go ahead, Ms. Mahoney.
Great. So again, given the ongoing state budgetary limitations and the fact that several of the international organizations or groups that we're a part of haven't yet worked out the details for upcoming meetings, a lot is still up in the air about next year's activities, but there will be further opportunities to engage. So first, the Global Privacy Assembly meeting. We know that will be held in Dubai in the fall of 2026. For the Asia Pacific Privacy Authorities, they always have a summer and a fall meeting, one of which is always virtual. The other is usually hybrid, and the hybrid one will be in a location yet to be determined. The Berlin Group likewise has a summer and fall meeting at locations yet to be determined. Hybrid options depend on the capabilities of the host organization. I know that the spring meeting will be in Europe, but they haven't nailed down exactly where. So those are the updates I have on some upcoming meetings. So similar to the process for domestic conferences, staff supports board members attending meetings of international bodies. We would support board members notifying staff if there's a meeting of an international body of which our agency is a member that they would like to attend. And then staff will coordinate with the chairperson and manage logistics to make sure that we're complying with existing law, including that no more than 2 board members are planning to go. So hopefully this will allow us to provide board members the support they need and ensure a streamlined process. So thank you. I welcome any questions, input, or feedback.
Thank you very much, Ms. Mahoney. This annualized agenda item was originally suggested by former board member Lydia De La Torre. And one component of it was her hope that we could do a little bit of planning for those situations where board members, rather than executive team staff or experts from our divisions, would be beneficial attendees. I would like to say a word about the Global Privacy Assembly. The Global Privacy Assembly is I believe, the first international organization we joined or close. It might have been the Asia Pacific Group. And it is crucially important for the privacy agency to have a presence at that meeting every year. It is the UN for privacy regulators, and it is a very high-level meeting. I know you'll have to work with state budget constraints, of course, and I'm offering my opinion that this is a key use of resources. I quoted the statute. This is what I would consider to be a mission-critical travel item. It is a function required by statute, contract, or executive directive. Although the statute doesn't say Global Privacy Assembly exactly, it does require us to do this cooperation, and it is very difficult to do the cooperation without acting on our membership in the Global Privacy Assembly. So my view is that it's something that I would like the staff to prioritize if at all possible. It's also something where the attendees are generally commissioners. It's been hard for our small board with our busy schedules to find time to attend. But if it's possible for one or more of us to go, that is something that I would encourage. And I think I'm channeling Ms. De La Torre in saying that. I think she was exactly right about that. So I just wanted to provide that comment. Other comments or questions?
Do we have any dates on that one?
That's a good question, yes. I was going to say, so I might be hitting you up and seeing if you can go to Dubai. We don't have a date yet.
We don't have a date. It's usually held in September and October, but I realize that doesn't help that much with your busy schedules, but I'm happy to provide that information once it becomes available, consistent with Bagley-Keene.
Wonderful. Thank you so much, Ms. Mahoney. Other questions or comments? All right. Is there any public comment on this item?
This is for agenda item number 3, annual intergovernmental affairs update and priorities. If you'd like to make a comment at this time, please raise your hand using the raised hand feature or by pressing *9 if you're joining us by phone. This is for agenda item number 3. Madam Chair, I'm not seeing any additional hands raised at this time.
Thank you, Ms. Carwile. Thank you again, Ms. Mahoney, and thank you to the board for the discussion. I need a break before we go to the next agenda item and suggest that we take 10 minutes a bit. So let's say 11:10, that'll be a little bit closer to 15. And we'll meet back here at 11:10 to resume the meeting. Thanks, everyone. Welcome back, everyone. This is the November 7th, 2025 meeting of the California Privacy Protection Agency Board. We are returning from a short break, and we will pick up with agenda item number 4, regulations, proposals, and priority discussion. This is an annualized item on our calendar in which the staff offer, based on research, some ideas for potential regulatory needs or other rulemaking priorities, and the board gives guidance and feedback. It will be presented by Philip Laird, our general counsel, Tamara Colson, our assistant chief counsel, and Lisa Kim, our senior privacy counsel and advisor and regulations extraordinaire. What do they call them in the UK? Supremo, our regulations Supremo. And I will introduce this just by saying, Mr. McTaggart and I may be the only ones who remember or were here for the last conversation. I am sorry, Mr. Liebert, if I shortened your time. I don't mean to. But we were talking about some sort of more specific concepts at that time. And as I understand, this will be talking about buckets, and we'll be talking that some of those concepts would fit into, and that we are at a moment in time in which we have completed the mandatory regulations that we needed to do. And we have completed updates to the CCPA regulations that were sort of more urgent, that went along with those updates. So we are in the enviable and happy position through the efforts of staff and so many stakeholders over time of thinking ahead. And thus my understanding is that the ideas and thoughts will be presented with an eye towards beginning a lot of fact gathering rather than immediately having regulatory language, for example, that we could consider. I see nods, and with that, I will turn it over to the team.
Thank you, Chair Urban. That was a perfect summation from my perspective. Exactly right, and exactly our intent here today. As was mentioned, the board decided to defer decisions regarding any additional areas for rulemaking at last year's discussion of this item, really to allow staff to focus on the agency's then ongoing rulemaking activities. However, now that our largest regulation package has been completed, we are able to turn our attention to more constructively to discussing future rulemaking proposals. But before going directly into our recommendations regarding rulemaking, we wanted to start off by level setting a bit. We know some members have not been through this whole process from the beginning before, and so we wanted to do a slight review of the Administrative Procedures Act requirements for adopting regulations. And so with that, I'm going to turn to my colleague and the champion of the legal division, Ms. Colson, to go over those details.
Thank you.
Everybody's a Supremo.
I agree.
Thank you, Mr. Laird, and good morning to all the board members. Can I get the next slide, please? Can we turn to? Okay, thank you. All right, so we just thought this would be helpful not only to the board members, but especially our new board members, but also to the public who may not be familiar with the Administrative Procedure Act, which we frequently refer to as the APA, that has California's rulemaking requirements. So as a quick review, we're going to go over, it sets forth 6 requirements that proposed regulations must meet to be approved by the Office of Administrative Law. The first two standards are authority and reference. Authority means there's a provision of law that permits or obligated the agency to adopt, amend, or repeal a regulation. Reference means the law we're implementing, interpreting, or making specific. For our agency, the reference is the CCPA as amended by the CPRA or the DELETE Act. We adopt regulations to implement, interpret, and make specific both of these laws. As for authority, our rulemaking authority for the CCPA comes from Civil Code Section 1798.15 A and B. Subsection A is very specific and identifies over 20 topics for which we have authority to adopt regulations. But we also have broad authority under subsection B to adopt additional regulations as necessary to further the purposes of CCPA. Our rulemaking authority for the DELETE Act is found in Civil Code Section 1798.99.87, which states that the agency may adopt regulations to implement and administer the DELETE Act. The next is consistency. This means that our regulations have to be in harmony with and not conflict with other laws. So for example, we can't invalidate an already existing or state federal law through our regulations. Fourth is clarity. This is a really big one when our regulations go through the OAL review process. Clarity means that the regulations have to be written in plain, straightforward language that will be easily understood by persons directly affected by them. This requirement is specifically about how the regulation is written. For example, we can't use words like reasonably or generally without some further clarification in the form of definitions or examples, because then we wouldn't make the clarity standard. You may recall that we raised this issue of clarity a lot with regard to the last rulemaking package. Fifth, we have non-duplication. This means that the regulation does not serve the same purpose as a statute or other regulation. While we sometimes do summarize things in our regulations for ease of reference for people, we are not supposed to write regulations that just say the same thing as the law. And finally, necessity. This requirement means that the regulation is necessary to effectuate the purpose of the statute or other provision that the regulation implements, interprets, or makes specific. In our previous rulemaking packages, this requirement has generally been met because we were operationalizing the law, and the statute specifically required us to adopt the regulations on certain topics. But we are now at the stage where the statutory required rulemaking topics are behind us, as the chair mentioned. So we are now thinking about this requirement as we assess and advise the board on rulemaking priorities. Some of the questions that we are asking ourselves to think through these rulemaking topics are whether a regulation is necessary to assist consumers in exercising their rights, avoid or mitigate privacy harms, including from threats, or help businesses better understand, operationalize, and comply with the law. Our recommendations today identify topics that may meet this necessity standard. And so I'm going to now turn it over to my colleague, Lisa.
Yes, and if we can have the next slide. So the next question is, what next steps would look like essentially in this process? And to be clear, if the board agrees that staff pursue the rulemaking topics that we recommend today, staff would begin by engaging with and investigating the topics to more fully assess where there is a need for regulations and what those regulations would be. So in other words, after receiving direction from the board, our next steps would be to engage in preliminary rulemaking activities. If you look at the slide, to just take a step back and look at the entire rulemaking process, this slide shows where we would be in that process. And you'll notice it's like right at the beginning. We would be in preliminary activities. And the benefit of this part of the process is that we have less restrictions on how we engage with the public during this time period. We also don't have a strict deadline by which we have to complete the rulemaking process, because that one-year deadline does not start until we actually file a package with OAL with regard to a notice of preliminary rulemaking. More specifically, the next slide, if I can have the next slide. This next slide identifies what those preliminary activities would likely include. And so we would start with conducting our own independent research internally. This would include leveraging our own staff's expertise and experience in these areas, as well as reviewing relevant studies, reports, and other published resources. We would also be engaging with academics and experts and other thought leaders on the topics through both formal and informal engagements. For example, we may elect to have public information sessions. Third, we would be engaging with stakeholders and consumers. Specifically, we intend to invite stakeholders and consumers to publicly comment on on each of the topics, including in response to specific questions that we'd like them to give us feedback on. And then finally, we would also be engaging with other agencies and jurisdictions with concurrent or adjacent jurisdiction. So if we can have the next slide. So with this background, I will move on to the staff's recommendations regarding the rulemaking priorities for the near future.
Could I interrupt you for 1 second, Ms. Kim? Well, interrupt you for a moment, I think, to ask about the preliminary rulemaking activities. I'm not pressing. Let me just back up and say, so my understanding is that the recommendations that staff will give us is related to the use of resources by staff and using the resources of the staff in order to engage in preliminary rulemaking. You need some guidance about the areas in which to do that, I understand. And I brought that up first because I know this is a resource question. Mr. Liebert has mentioned a couple of times, and I have also really valued the previous stakeholder sessions we had and the expert forum that we had when we were developing information that ultimately supported the 2 large packages of regulations. And I just wondered if those were possibilities that could fit into this bucket.
I can go ahead and take that one just because, first of all, yes, the short answer is yes, absolutely we can, and we're excited to do so. One point of clarity, though, because I think this may come up also when we talk about the annual calendar, is really just making sure we have a good sense of the board's expectations of their engagement in these sessions. Certainly, staff can set up one of these sessions sort of any time for a sort of a staff level engagement and opportunity to hear from the public or for certain stakeholders. If a majority of board members want to attend and, for instance, ask questions and participate in a session like that, we would need to then still comply with Bagley-Keene. And so I raise that point just because depending on whether or not it's a matter of board members want to hear that feedback, maybe either during or after the session, that can sort of be done individually by board members at any time based on something staff has put together. But if at any point the board would like an opportunity to actually, sort of have that two-way dialogue with stakeholders participating or to learn more about a certain topic, we would just want to make sure we schedule that as a Bagley-Keene compliant meeting.
Thank you. And that does tie to resources because we do realize that we are a production to some degree. Mr. Liebert?
Thank you for that, Phil. Yeah, I again want to encourage the board to think about the benefits now as we're becoming more and more mature over the years, that that we actually dedicate time for education of ourselves and frankly of the public as well. And I know that this may have implications in terms of the possibility of using, for example, a Thursday afternoon meeting prior to another board meeting on a Friday for that type of educational purpose. But in answer to your point, Phil, I do see it as at least a two-way, if not a 3- or 4-way conversation where we can have board members interact with members of the public who want to speak about various key issues, some that you've identified here potentially as potential regulatory issues, academics, members of the technology industry, all the different stakeholders, to have that type of process available that we don't normally have in a typical board meeting. And I think that could be really advantageous in a lot of different ways. So I still encourage that and hope that maybe these examples of the regulatory investigatory process now would really lend themselves to that type of process.
Thank you, Mr. Liebert. All right. Now that we've said do more with less, please go ahead to the topics.
Great. So we have 4 recommended topics for this, the board to consider today. And I'll start and go through, describe them each in greater detail. So number 1 is employee data. And as you know, the definition of consumer under the CCPA includes all California residents, including employees or job applicants, independent contractors, and such. There was initially an exclusion for employees and independent contractors, but that provision sunset back in 2023 or 2023. So over the years, we've received a significant amount of feedback on issues related to employees, independent contractors, job applicants, and how the CCPA applies to people within the work context. This is also a topic that the board has previously identified as needing attention in our future rulemaking. So topics we intend to explore on this subject would include whether there's any need for clarification on how the CCPA applies to employees and business practices in the management of employee data, and whether regulations can assist or clarify for businesses how to provide the necessary disclosures to their employees, as well as how to process employees' data requests or employee CCPA requests specifically. Moving on to the second topic, we've identified disclosures and notices. So the CCPA requires several different disclosures to consumers: notices at collection, privacy policies, notices of financial incentives, et cetera. And so while these are required under the law, there is also a growing body of privacy scholarship that recommends policymakers move away from a notice and consent regime. So the questions for us here would be things like, how can we make notices more effective? What are consumers most interested in knowing? Where do businesses need help in making disclosures? What do consumers find the most confusing about notices? Another question would be whether an executive summary would assist consumers, and whether or not model or template formats would be helpful. We would explore how we can leverage academic research and consumer experience to provide guidance and clarification to businesses who are responsible for giving notice. And this topic would also incorporate multiple concepts previously raised by the board at past priorities discussions. Third, reduce friction in the exercise of privacy rights. As we continue to raise our public profile, we are receiving increased feedback on the difficulties consumers are facing in their exercise of their CCPA rights. And this feedback comes to us in all different kinds of forms. They come from consumers directly, authorized agents, academic studies by experts, and then also from reports by community organizations. So this topic specifically would explore whether there is a need for any additional regulations to address things like dark patterns or other hurdles consumers are facing, or consumers or their authorized agents are facing in the exercise of their CCPA rights. And it may include a review of identity verification and authorized agent procedures, investigation to whether businesses are deliberately hiding or making it difficult to find opt-out pages, as recently reported by CalMatters, and evaluation of current industry activity to determine if further clarifications are needed in the regulations. And then finally, opt-out preference signals. We recommend that the board direct staff to review our OOPS regulations to see if any changes or clarifications need to be made considering the changing legal landscape. As the board knows, the governor signed the California Opt-Me-Out Act, AB 566, into law. While there is no need to adopt regulations to implement that law specifically, the governor also signed AB 1043, which implements age verification signals that protect minors. And this is in addition to the passage of SB 976 last year, which tasked the California AG's office with adopting regulations regarding age assurance and parental consent. And then we also have several other states passing similar OOPS bills. So staff believes it would be a worthwhile endeavor to review our regulations to see if there's any further need to harmonize signal requirements or provide guidance on how different signals should be processed. We would also explore signals that would exercise a consumer's right to limit the use and disclosure of sensitive personal information. And we would also collaborate with other agencies and jurisdictions to determine whether age assurance or other state agencies or other state signals should be considered opt-out preferences under our law. So those are the 4 areas the staff recommends engaging in for preliminary rulemaking activity.
And I'll just say, those are just a few trivial ideas, right? No, I'm kidding, because I'll just close briefly by saying those are obviously very big topics, very wide open subjects. And so we do anticipate that the research and inquiry will take some time. Our plan would be to immediately commence pre-rulemaking through the various means that we described earlier, and then return to the board with more specific recommendations as they come into focus from a staff level. So one thing I'll note is that we don't intend to proceed with multi-topic packages like we've done historically. Instead, we plan to present more targeted recommendations that seek to address perhaps only 1 or 2 policy issues at a time. And through this approach, as you can imagine, it means we'll return to the board at various meetings throughout the next year and beyond with specific proposals falling into at least one of the 4 categories discussed today as they are ready. So again, thinking of our very massive package that cut through virtually every privacy issue in one way or another previously, the goal would be to really focus on topics, focus on policy, and not necessarily combine those, but give the opportunity to focus on them. And at the same time, we think that'll achieve an efficiency actually of being able to move those packages through a little bit faster. So of course, we will be happy to update the board on our progress as we move through 2026 as well. But I wanted to make clear at the outset that this path will have us coming back to the board at different times with different proposals. We don't just assume we're going to have a across the board update at our very next meeting on all 4 subjects. Instead, we'd like to give these each topic the appropriate amount of time to sort of ripen and develop in terms of our research and our stakeholder engagement, and then bring you truly, sort of thoughtful, data-driven and stakeholder sort of engaged topics as we're ready. So with that all said, happy to field any questions. We really look forward to this discussion and any suggestions from the board, both about subjects or process. I just want to make clear already some great suggestions about how we lead informational sessions. And the great thing about pre-rulemaking, as discussed early, is sort of the world is our oyster. We have a lot of options on how we proceed. And so happy to leverage any thoughts or suggestions from the board.
Thank you very much. To the team, Ms. Hamer?
Yeah, 2 hopefully pretty easy questions, but do you have a prioritization in mind for these? Do you have a prioritization in mind? How did you come to these? Kind of along the same lines as my prior questions, and were there, because they're big buckets, they cover a lot of territory. Were there any other buckets that you thought about and declined to put forth?
Excellent questions. Taking actually the latter question first, I'll just say, well, no, I'll start with the first. In terms of priorities, the good news is we have a good sized legal division and full of talented experts. And so where some of our rulemaking packages took sort of the energy of the entire legal division previously, my goal would actually be to tackle these topics simultaneously, sort of divided among our staff. So the short answer is the priority is all 4 at this stage, but I do recognize some certain subjects, employee data, that's a pretty big topic with a lot of sort of potential pathways. And so something like that may take longer for us than, for instance, a review of the signal requirements and coming back with sort of targeted recommendations there. In terms of the topics we chose, and I'm gonna turn to Ms. Kim to fill in any gaps I leave. A few things motivated this. As was alluded to by the chair, the board has previously identified sort of specific, slightly more targeted concepts in the past, and we are not by any means ignoring that list. In fact, that influenced a lot of these topics because we thought these covered the majority of what has been raised previously by board members. But we recognize instead of sort of just continuing to focus on very specific ideas, this is really that opportunity to do broader information gathering and really assess actual harm happening today in the real world and see where we could be most effective for consumers and also for businesses. That was another point I wanted to emphasize is earlier, I think we heard a comment about, we just finished one rulemaking, businesses need time to come into compliance with that. One theme in Ms. Kim's remarks that I just emphasized was how we can help businesses, how we can make guidance more clear, how we can make standards more achievable. And so I hope when any business listening in today hears that we want to do more rulemaking, we have them at the front of our mind as well and thinking about what is not working in our regulations, what is creating, a regulatory sort of nightmare for them or complex situation or conflict even potentially, and how can we resolve that? And certainly as new technologies and practices are evolving, how can we provide greater clarity of how our existing standards map onto those new scenarios that businesses are encountering? So I want to be very clear, this is for their benefit as well, and not necessarily just as a means to create new requirements for the sake of doing so. With that said, Ms. Kim, do you want to fill in a little bit more on our thinking of what's...
I think he covered. Mr. Laird is very good at this.
Thank you. Mr. Liebert has a question or comment as well. I'd like to follow up on Ms. Hamer's questions and your response, Mr. Laird, briefly, if I could, to highlight the possibility under item 2, disclosures and notices, to develop model or template forms, as well as other methods for making notices both easier to understand for consumers and implementable by businesses. I just wanted to say a brief word about that because it is a quirk, is maybe not quite the right word. It is a feature of the Administrative Procedures Act in California that we can't just make model notices for businesses. And we have to use a rulemaking process, as I understand it, to do a lot of those things if they're specific enough. We've had, a lot of comment from particularly trade associations for small businesses whom I really wanted to help. And I wanted to be sure that they understood that if this is something that the staff finds would be helpful, would pan out, would be something that we could do, that would be very directly targeted at helping both the consumers understand, but also the businesses with implementation. And it's just something that I think is not necessarily intuitive for people. I've been asked for guidance so many times, specific guidance on things. I understand it. I know we'd love to provide it, and we do have to follow the process to make sure the public always has a seat at the table. So that's one example of where I think that sort of two-sided benefit is important. And I have, without meaning to, departed a little bit from Ms. Hamer's comment. I'm sorry, Mr. Liebert. Please go ahead. And then Mr. McTaggart.
Well, I think these are excellent recommendations. And they cover a lot of territory, really important territory. And I very much appreciate the point you made that we very much want the business community involved in this process so that we can get these approaches as reasonable and right as possible. I want to focus again on one of my major areas of concern that I've talked about at other meetings, and that is on the disclosure and notice process. The one kind of consensus I think I found over the years is that whether you're a business or a consumer, no one thinks this process is working well at all. We all go through it. I wanted to download an app this morning, and I got that famous screen that we all get, which is in order to use that service, I agree to all of the terms of service, and I also have read the 60,000-word privacy policy. Did I do that this morning? I did not. I did what we all do, at least most of us, and that is we get in the car and drive it even though we know we may not be safe. And so to me, this is a really critically important issue. The system's not working. I don't know what the answers are. As you just alluded to, Madam Chair, maybe it's the old nutrition label idea, though other academics have downplayed that as well, that it's too simplistic. I know it's not fair to a lot of businesses because it is useful in a way for regulators, as I've learned, to see all of these types of issues put down in writing in a privacy policy, but it's not for the consumers. And it's not for any of us when we sign up for these products. It's a false system of privacy. We have to address this. So I'm very excited that that's one of the issues that you've chosen. The other one that I want to note that has obvious complexity is the legislature, as you know well, is focusing on employee rights right now in these areas. And so working with the legislative community on this will be super important for us to get this right. I know you know that, but that has its own complexity as those efforts are being made in the legislature. And of course, I just think this is a great set of issues for us to look at, and I hope we can at least do some of them through an informational process as well, so we can all talk about these issues in a longer period of time where we're not pressed for doing it in a half hour, an hour, whatever. So really appreciate all the great work that you put into coming up with these. Thank you very much.
Thank you, Mr. Liebert. Mr. McTaggart?
Sorry. So question is for Mr. Laird, is it your intention that like right now on these topics, you would get our feedback on an individual one, or sort of like these are the topics and we'll bring them back and we're, okay, now we're going to discuss employee data, you know, or this month it'll be something else. What's the process or?
Yeah, great question. I mean, I think it's a little bit of both in the sense of certainly we welcome any feedback on these topics generally. And if there's sort of lurking other topics that these don't seem to cover that we think are pressing and important, we of course want to hear that from the board. And at the same time, whether you want to share it now or individually with me at a later date, even outside of a board meeting, also welcome more specific ideas from board members about these topics, about interests they have in them. Again, noting that certain things that have been raised at previous meetings, we've taken careful note of. And so we recognize there are certain topics that you and other board members have raised in the past that we think fall into these categories that'll be part of our research we conduct. But certainly, if there's anything on your mind at the moment that you think is worthy of kind of raising and helping focus the types of questions we ask and the type of inquiries we make, we'd be happy to hear that right now.
Okay, well, sure. I'd like to echo a lot of what Mr. Liebert just said. I think with the employee data, obviously it's top of mind for the legislature, and kind of like with ADMT, I feel like we should defer to the legislature, let the legislature legislate, especially about a different topic, which is employer relations. This is a privacy bill, and I really would urge us to stay in our lane and obviously, cooperate them to the extent possible. But I really, as with sort of efforts to use this bill to regulate AI, I would urge us not to use it to try to, step too far afield into the employee-employer relationship, which is ongoing, a topic for the legislature. I couldn't agree more with his comment about you just say yes, accept. I do it all the time for the 60,000 word privacy policy completely. And to the chair's point, if we need, and I don't even know with the APA, but if we needed authority to be able to say, yep, we can publish these model documents, and that needs to be a bill. That seems to me a good area, because I think this is so complicated. And like the chair, I get this all the time from businesses. And if they were like, oh, I know that this is a safe harbor, if I can read that document and I can attest to it, that can be our document. Boy, we'd save a lot of time. And I think it would make it easier for businesses to comply with the law. And then my final thing on the opt-out preference signal would just be getting back to Dr. McDonald's point, would be to make sure that there's an option for, hey, this device, whatever you think about who runs this device and who it is, I want you to opt out everything associated with this person. And I don't have to put in my email address and my address and my phone number. So those are my running down that, my quick reaction to these topics, which I think are all important and great. And I'm happy we're having this discussion. Thanks.
Thank you, Mr. McTaggart. I find myself in agreement with Mr. Liebert and not in disagreement with Mr. McTaggart, but possibly have a softer view with regards to the employee data. It is something the legislature is focusing on, as they have both said. It's a crucially important area, and it touches on obviously labor relations and a lot of things. So I think that the humility is a good posture with which to start, and really endorse Mr. Liebert's mention of working with the legislature, which I know you would do anyway. The reason why my view is a little bit softer, I think, than Mr. McTaggart's maybe, I don't want to mischaracterize his view, is because we have heard a tremendous amount about the privacy implications of the employer and contractor and employee or contracting party relationship over the course of our last rulemaking. It is clear to me that not only does our law cover this data, and it covers it, but that it is profoundly important for the privacy of natural persons resident in California, which is what consumers are defined by as the statute. So I think it is actually incumbent upon us to explore the issue pretty carefully, given that it is under our jurisdiction. That is partly for workers, but relatedly, I've also had questions from businesses like, this isn't how I've generally thought about this issue. I haven't thought about this as a consumer privacy issue. You know, I'd like to implement this, but I'm, I just feel puzzled. And so it becomes an implementation question for businesses as well. So I think it's crucially important to work hand in hand with the legislature, with the governor's office, with the Labor Department, and so forth, and to be thoughtful about how many different things and systems we might be touching when we're working on this issue. But I do think it is important. I think it's something we've had questions about and heard about from the very beginning of the agency's inception, and thus I think it is an important issue to explore. Ms. Hamer?
Yeah, so I pretty much agree with what you're saying. And the data flows within companies regarding employee data are so different than the data flows regarding consumer personal data. So we do have to keep in mind the operationalization of that and the impact on businesses. And then with reducing friction in the exercise of privacy rights, I love that. I would also like to reduce friction for the businesses in complying with what they have to do, because I do think there are not public conversations or thought processes that are like, I'm going to roll the dice because I just don't know what to do with the way our systems are architected. How do I even comply with that? And are they going to come find me? So I appreciate the comments about keeping the business in mind while we're going through the process.
I'll just say thank you for all that feedback, immensely helpful. And I will commit right off the bat that we definitely plan to stay in touch and coordinated with the legislature and other stakeholders. And I really want to support what was just shared from a number of the board members. You know, employee data, that one especially is one where my comments earlier about wanting to help businesses, I mean, because the truth is, right, CCPA applies to this data today. And I want to note, you know, a recent settlement approved by this board with Tractor Supply Company actually was an issue of a deficient notice to job applicants about how their data was being used. So my goal, threading to, you know, some themes together here, for it, perhaps we end up with a situation where we do have a template notice now for job applicants that we can help businesses operationalize these rights and make sure protections are in place, but it's not at sort of any detriment to the business to implement. So our goals are shared, and we can commit to fulfilling all that.
Thank you, Mr. Laird. Mr. McTaggart, I wanted to give you an opportunity to react if you have one.
Yeah, of course. I actually think that last comment is a great one. If you could have sort of a template for employee data, you know, I'm not obviously trying to say that under the law that the employees are not consumers. I just also think that we should keep in mind that we're a privacy law, and it's really about what happens to the employee data as opposed to trying to use the law to regulate businesses in non-sort of privacy-centric ways. And I think there's been a bit of an effort of that. And I think, you know, for example, a lot of the ADMT stuff where it would really have rendered business unable to, you know, to carry out its normal operations. You wouldn't be able to, some of the drafts, you wouldn't be able to, you know, do a lot of what business normally does, and not to defend business necessarily, but, you know, if people want an Uber, they're going to have to rely on the algorithm to get the car to them. So anyway, we don't need to go there right now. I think I'm probably a little bit more on the let the legislature legislate in areas that are not covered by privacy here. But let's wait to see what we're doing. And I do share your idea of if we can get model forms, I think it would be super useful for so much. So.
Thank you, Mr. McTaggart. And I will say the legislature must legislate on things that don't relate to things under our jurisdiction. So I think we're all in agreement about that. That is the legislature's job, and generally it's very important to collaborate and coordinate with them as well about how we're exercising our jurisdiction. Do you need a motion, Mr. Laird, for us to move forward if we think that we are happy for staff to start the preliminary rulemaking information gathering process on these buckets informed by the discussion today? Or is this the information you need?
Yeah, I was going to say legally, a motion really isn't required at this
Okay.
stage. Preliminary rulemaking is only that. Only once we proceed to formal rulemaking would we need some, legal authority from the board to proceed. We've heard, I think, the comments really well today and are taking careful notes and plan to commence right away with sort of the agreement we're hearing and the concurrence we're hearing from you all. So not necessary. It's always allowed. They're not prohibited, but not needed.
Okay, wonderful. In that case, I will ask Ms. Carwell if there's any public comment.
Okay, this is for agenda item number 4, regulations, proposals, and priorities discussion. If you'd like to make a comment at this time, please raise your hand using the raised hand feature or by pressing *9 if you're joining us by phone. This is for agenda item number 4. Matt Schwartz, I'm going to unmute you at this time. You'll have 3 minutes. Go ahead and begin when you're ready.
Good morning. I realize I may have said good afternoon last time, which is very embarrassing because it's not the case for y'all. Once again, my name is Matt Schwartz. I'm a policy analyst at Consumer Reports. Thanks for the opportunity to speak about Cal Privacy's forthcoming regulatory priorities. I'll focus primarily on regulatory proposals for reducing friction and opt-out preference signals. Through our work operating the permission slip authorized agent app, as well as manually guiding everyday consumers through submitting rights requests, we've encountered a wide range of business practices whose net effect is to make exercising privacy rights more difficult than it should be. These practices range from plainly illegal to simply violating the spirit, but perhaps not the letter of the law. These practices tend to fall into one of several buckets. First, verification. Some companies simply ask for more verification than is reasonably necessary to complete a request. Second, some companies misrepresent which states they support privacy requests for or have confusing language about what states are eligible or when rights may apply in certain circumstances. This information should always be clear to consumers. Third, some companies just core privacy request flow simply doesn't function in critical ways, including broken opt-out links or invalid email addresses. And fourth, and perhaps most commonly, companies may use inconvenient flows overall for privacy requests, and that can manifest in any number of ways. For example, some companies make it impractical for authorized agents to submit requests or for them to receive updates about the status of a request that they are effectuating on behalf of a consumer. Some companies ask consumers for excessive data to complete a request, which I know came up earlier, or require them to spend just kind of far longer sending a request than is necessary. And other companies forbid consumers from sending more than one request at a time, which can cause consumers to ultimately wait weeks to fully exercise their rights at a single company. These practices are already prevalent in the marketplace, amongst just the companies in the permission slip app. We're seeing one of these practices at roughly 30% of the companies. But with the passage of the California Opting Out Act last month, it will become even more crucial that consumers' preferences to opt out of their information being sold or shared for targeted advertising is not stymied through kind of adversarial design decisions.
Thank you. That is the time. Tim Newman, I'm going to unmute you at this time. Go ahead and begin when you're ready.
Thank you. Good afternoon. My name is Tim Newman. I'm providing comments for Tech Equity, particularly on potential rulemaking activities related to employee data. The need for stronger protections for workers is significant and likely increasing. For example, data collection, automated surveillance, and monitoring are widespread across the workforce and are strongly related to negative health and safety outcomes for U.S. workers, according to a national survey published by the Washington Center for Equitable Growth. Hundreds of tech products identified by coworker.org are collecting and aggregating data about workers at almost every step of the labor process. The data that is collected on employees is used to make highly consequential decisions that impact Californians both at work and throughout all sectors of their lives. And now companies are increasingly marketing agentic AI tools that they claim have the capability to initiate and execute actions based on data collected from workers. However, the National Employment Law Project notes that businesses' increased adoption of new surveillance technologies threatens the efficacy of a wide range of existing legal protections for workers and exploits missing protections in other areas. Even CalPrivacy's regulations related to ADMTs allow almost all companies to avoid accountability, exempting 90% of entities covered by this agency. As you further explore this topic, we encourage board members to review recommendations previously submitted collectively by 45 different organizations and unions, including Tech Equity, in January of this year, for ideas on how to strengthen regulations related to employee data. Californian workers are concerned about the impact of AI on their livelihoods. Recent polling commissioned by Tech Equity found that a majority of Californians, 55%, are more concerned about the future of AI than excited. Over 2/3 of Californians want the government to establish safeguards around AI systems, and personal privacy is one of their top concerns. And workers want a voice. Polling by Gallup found that US employees who say they have a lot of influence over which technologies are adopted in the workplace are more than twice as likely to report high job satisfaction. To ensure that rulemaking effectively meets the needs of workers, meaningful consultation is necessary. In the work setting, harms from the collection and use of worker data result from a power imbalance between employers and employees. This same principle applies to the regulatory process. Industry associations representing employers and the tech companies that profit from widespread collection and use of employee data have enormous resources and influence when compared to workers. We have previously shared our perspective that CalPrivacy's recent regulations on ADMTs were weakened with every successive round of industry lobbying. Moving
Thank
forward,
you.
we
That
hope
is
for
your time.
robust engagement.
Oh, no, it's not. Sorry. I
Moving
apologize, Mr. Newman. That was an alarm that was not related. I will stay out of the moderation, and I apologize for interrupting you.
No worries at all. Moving forward, we hope for a robust engagement process with unions, experts, and impacted communities to ensure that any rulemaking process is responsive to the realities of working people. CalPrivacy can continue to be a leader of the nation as the only state privacy regulator in the U.S. We encourage board members to use their mandate and authority to deliver protections for workers, and we look forward to continuing our engagement with the board members, and just wanted to extend a warm welcome to board member Hamer.
Thank you. That is your time. Alicia McDonald, I'm going to unmute you at this time. You'll have 3 minutes. Go ahead and begin when you're ready.
Thank you so much. Loved the comments in this last section. Let me raise a comment that I heard go by briefly from committee member McTaggart around the idea of California having adequacy for GDPR. In particular, let me also tie that to the questions around notice and choice and removing friction from users' decision-making in the following regard. Because in Europe, where I am right now, greetings from Portugal, we opt into tracking rather than opt out of surveillance. That means that we no longer have the agency problem where companies are incentivized to make it difficult for people to make decisions and effectuate those decisions. So I would like you to consider that we actually have a different series of threads that all come together here. And no, this isn't something that you're really necessarily expecting to take on today, but moving to a situation where perhaps people are instead presented with an opt-in or opt-out choice rather than a default. That might be something that moves in a direction that gets to more fairness. or to actually match the EU standard, which would then make it easier to get adequacy for GDPR by far. So I think those are things that might be interesting to think about from the perspective of user choice, since we know that notice and choice does not serve people, and the comments made about, I get in the car even though I know it might not be safe to drive, and then we all click yes without reading things. All of those are great comments. It's been decades we've been building this record, and Chairwoman is very familiar with all of the work on this, and I appreciate her work on it too. Thank you very much for your time. Something to think about.
Thank you for your comments. Again, this is for agenda item number 4, regulation proposals and priority discussions. If you'd like to make, if there are any other members of the public that like to speak at this time, please go ahead and raise your hand using Zoom's raise hand feature or by pressing *6 if you're joining us by phone. Again, this is agenda item number 4. Greg, I'm going to unmute you this time. You'll have 3 minutes. Go ahead and begin when you're ready.
Hi, thank you for letting me speak. I'm a consultant and I've been working in the area of verifiable credentials, which are digital credentials beyond just a digital driver's license or digital ID. And I'm particularly working on the area of standardizing these at places like the World Wide Web Consortium and the IETF, and working on privacy enhancing aspects of those. So it's a new area, but we have all the potential tracking issues like we have on the web and mobile apps. So I don't know if it belongs under recommended topics or future topics, but I wanted to bring that up and invite folks. We can, I work with once again, the IETF and the W3C as an invited expert on this area. And we've got all the same concerns about privacy, and it's just one more place that we have potential for a lot of, helping out businesses, helping out consumers by using digital IDs, but we also have a lot of privacy concerns, and we're trying to promote that. And so I just open that up, and I've done a number of presentations for at the W3C and things like that on this topic, whether it belongs here or future. I'll leave that to you guys. Thanks for letting me speak.
Thank you. Again, this is for agenda item number 4, regulation proposals and priorities discussion. If there are any other members of the public, please go ahead and raise your hand at this time. Madam Chair, I'm not seeing any additional hands raised at this time.
Thank you, Ms. Carwile. Thank you very much to the members of the public. And I will leave moderation to the professionals next time. I again apologize to Mr. Newman and do appreciate his comment. I'm going to go ahead and call agenda item number 10 with the plan that we would discuss that over lunch. It is the closed session item, but before I do that, I need to briefly confer on a process issue with Mr. Laird and Mr. Kemp. All right, thanks everybody for your patience while we dealt with a technical issue, which was about the coverage of the closed session item. So we will proceed to closed session, leaving this room to discuss personnel matters under Authority of Government Code Section 11126A1. Please note that the agenda for today's meeting does include another item, 10B, for the board to meet in closed session to confer and receive advice from legal counsel regarding litigation for which disclosing the names would jeopardize the agency's ability to conclude existing settlement negotiations to advantage. That sub-item, however, will not be heard in closed session today. Therefore, while it is on the agenda, in case we did have it to discuss, we do not. We will focus on the personnel matters item. With that, we will go into closed session. We will not be back before, let's say, 12:45, in case folks who are attending would like to get some lunch or otherwise take a break. We'll make sure not to come back before then. Thank you very much. The California Privacy Protection Agency Board's November 7th, 2025 meeting. The board is now returning from closed session, which was agenda item number 10. We have completed that item and we will move forward with agenda item number 5, a presentation on the delete request and opt-out platform, commonly referred to as DROP. And that'll be an update and a presentation. Presented by our General Counsel, Phil Laird, our CPPA attorney, Liz Allen, and Art Andrusoff will not be joining us, but he will be here in absentia through the system that you are about to experience. So thank you, Art, for everything that you've done. I believe that we do have a slide presentation for that, and we'll ask everybody to turn their attention to it, and otherwise I will simply turn it over to the presenters.
Thank you, Chair Urban. We're really delighted and excited to share this presentation today. You've already discussed and heard a lot about the DROP system in past meetings as well as in today's meeting earlier. And so today we get to take you on a little tour of what it's looking like in lead up to our launch on January 1st of 2026. Before we get started, just a few, I'll start by celebrating a few folks. I was thinking about it, and in many ways, this system is a tale of two directors. We have obviously Director Kemp, who's with us now, who also then was advising and behind the legislation that directed our agency to create this system. At the same time, when this legislation first passed and we had to start thinking about how are we going to build the thing, we had the fortune of having Ashkan Soltani as our director. And much of the design of this system is to his credit and to his sort of thinking through what privacy protective means in the law and what privacy protective means in practice for a state system. So I want to start by honoring and recognizing our two directors for their contributions to this system. Secondly, I have to absolutely recognize the immense efforts of Liz Allen, the attorney next to me, who has done way more than legal work to get us to where we are on this project. From the moment this bill passed, she was the first one to create the registration within the agency. And from there has also been just not just an asset, the asset to help us get to this point for development of the system. Artem Andrusoff is also our chief of IT, who has also been a significant player in helping get this system to where we are today. He was slated to be here, but unfortunately was taken ill, so I'm sorry he's not able to join us, but he is with us in spirit. I'm sure he's watching online somewhere at the moment, and again, has just been a crucial partner. It was mentioned earlier, and I'll say it again, the Department of Technology has also been a crucial partner. A new agency with such a monumentous task was really had a lot to do here, and we recognize that there are resources and departments bigger than ours and with further sort of depth of knowledge and experience that we could leverage. And so it was a great partnership we've entered into with the Department of Technology as well. Finally, I am very, very delighted to introduce you to the person to my left, Marissa Rosenblatt, who joins us now at the agency as the Assistant Deputy Director of Public and External Affairs, overseeing the DROP system and the Delete Act implementation generally. So it was referenced earlier, sort of product manager had been brought on to kind of oversee these, and that is Marissa. I say I'm delighted because until now, I sort of was the deputy director in charge of this thing, and that's kind of crazy. But now we have somebody truly with just the skill set and expertise and background to bring the system to the next step and to bring it to the public. And so I'm delighted to have her on board. She's closing out her 3rd week with us and is already running meetings and everything. So Marissa, welcome.
Welcome, Ms. Rosenblatt. It's wonderful to have you.
Thank you so much. It's wonderful to be here and to meet you. I'm really excited. The team has been great, and we're doing some really, really cool work. So really excited. Thank you.
I promised I wouldn't really put her on the hot seat too much today. Again, 3rd week on the job. But with that said, we're delighted to go ahead and kick off our presentation. So I'm going to turn it over to Liz. And can we move to the next slide, please?
Yeah, great. So just for the benefit of the public and to kind of situate ourselves in history, we'll do a brief perusal through the data broker laws in California. Of course, states have developed data broker registries to help bring data brokers and their sales practices and collection practices out of the shadows. And they help make consumers more aware of the businesses and the impact they can have. And they, of course, allow us as regulators to have better visibility and oversight into the industry. And this is not it's a relatively new concept, but 2019, the first data broker law passed in California. The Attorney General, the Office of Attorney General, administered this law. And the bill was specifically created to make it easier for consumers to exercise their new rights, the new CCPA rights that had gone into effect in 2020. So the registry the Delete Act the Data Broker Registry Bill lines up closely with the CCPA, using many of the same definitions, like the definition of personal information, the definition of sale. Those are all pulled from the CCPA. And the Attorney General administered this for 3 years. And of course, importantly, it defined data broker in the California law. Like, what does it actually mean to be a data broker? Which is a business that knowingly collects and sells to third parties the personal information of a consumer with whom the business does not have a direct relationship. And the AG, of course, set up the registry, and it was funded through its own fees, through the fees that data brokers pay to register. So with Tom Kemp's help, our agency executive director, although at the time not working for the agency, they created a new bill, and it was called the Delete Act, and it was signed into law in 2023. And recently, I'm like, is this the next slide? I think this is the next slide. Sorry, I need to tell you to go to the next slide. There you go. So in 2023, and so the Delete Act updated the registry requirements, and then of course it transferred the registry from the Attorney General to Cal Privacy, and then added this big requirement to build the accessible deletion mechanism, which is where consumers can send a single delete request to all the data brokers on the registry to help them effectuate their CCPA delete requests in a much faster and more streamlined manner. And SB 361 is the newest law in the group, which passed just this year. And it adds additional registration disclosures about collection of certain personal information, including new categories of sensitive personal information. It also requires the disclosure of sales of personal information to certain entities. These are all defined terms like foreign actors, developers of Gen AI, and the federal government. So we'll be getting additional information in the 2026 registry, so all of this will be implemented in the drop. So let's go to the next slide. Okay. So let's just take a quick reminder for folks that a data broker is a specific definition within the statute. And up here, you'll see that a business, so I read the definition before, but I just want to say that sells, third party, business, personal information, consumer, these are all defined terms in the CCPA, so we import those definitions in the law. Direct relationship had no definition, so we have defined that. Our regulation package, which you mentioned, will be in effect in January, defines direct relationship to mean that the consumer intentionally interacts with a business. And of course, a business is still a data broker if it has a direct relationship with the consumer, but also sells personal information about the consumer that the business did not collect directly from the consumer. So That's clarified the definition and will be in effect for the January registration cycle.
We can go ahead and move to the next slide, please. So when we think about the Delete Act, there's really 4 major components to this law that we'll just briefly refresh the board on. First, data brokers, as described, are required to annually register with the agency every January to report the activities of their previous year. And this is something we like to often emphasize when we do presentations, because I think it's not always intuitive for folks that they recognize that registration is not an intent to operate in the coming year. It's actually a declaration of the activities you've already done in the previous year. So as you can imagine, there are certain situations where a new business who has never brokered data before or operated as a data broker will not necessarily register in January of the year they start operating. They will register the January following that one. A second component, of course, is what we're here to talk about today, use of the drop system to process deletion requests submitted by consumers. A third component is that data brokers are also required to make certain disclosures about the types of privacy rights requests they're getting on their own websites and privacy policies. And then they later report that as well within their registration information as well. And the final component is that they also, beginning in 2028, are going to be required to conduct an audit every 3 years with an independent auditor regarding their compliance with all of these requirements in the Delete Act. That's another powerful component of this law that we're excited to see take effect. With that, I should mention now to the board, we talked about rulemaking priorities earlier today. I will say this audit function will necessitate some rulemaking. So in addition to the areas we discussed, Ms. Allen has her own little project on the side she'll be working on. So you can expect some more.
You're not done with me yet.
Yeah, you can expect more on that in the year to come. Next slide, please. And so again, a brief refresher on the timeline we've been on. We've really had this kind of phased implementation of this law. Obviously, Cal Privacy began administering the registry back in 2024. And so we have now completed 2 registration cycles at the agency. And then starting in July 1st, 2024 is also when data brokers were required to start posting those metrics that we discussed on their own websites and privacy policies. And then beginning in January of 2026 is when we will be launching the drop system for consumers. So importantly, this is when consumers will be able to start entering the system, adding their information. But an important nuance to this timeline is that data brokers, on the other hand, are not actually required to start processing those deletion requests until August 1st of next year. That's an 8-month gap, actually, between when consumers can first input their request to when a data broker is required to process it. And so we want to emphasize that now for anybody listening and for board members to really understand. Absolutely, we encourage folks to get in as soon as they're ready and comfortable to submit through our system, but recognize that a submission in January won't necessarily mean deletion in February, right? It means ultimately deletion won't be required by law until later in 2026. And that's when you will see essentially all data brokers who are registered actively processing these deletion requests. And then finally, as was mentioned, the kind of final date to keep in mind in the back of our heads is that this audit requirement for compliance kicks in for data brokers beginning January 1st of 2028. Next slide, please.
Next slide. Okay, I think you've seen this. Oh, yeah, you have a question?
Ms. Stotherford has a question.
Can we go back to that prior slide just for a sec? Are you going to tell us at some point, looking back now, how the registration process has worked in terms of compliance with those dates, those deadlines? I'm kind of curious about that.
Generally with just how registration has gone?
Yeah.
Yeah, that's a great question. I mean, I'll start by saying, we've seen consistently, at least over the past 2 years, in excess of 500 data brokers registering with us. And I would say the vast majority do so in the registration timeline. That said, I think we've seen registrations come in sort of at all times in the year, indicative of different situations that I probably can't comment on because I'm not the one investigating necessarily on whether or not they should have registered at a certain point or what the nature of the issue was. But by the same token, I think staff feels comfortable saying we suspect and in fact are pretty well sure that there are other data brokers out there that should be registering that have not.
Do we have a sense?
Oh,
It's hard
how,
to know.
how many?
Yeah, hard to know.
Hard to know. I think we've heard estimates from it should be double to it should be 10 times who are registered. At the same time, again, I don't, Ms. Allen probably knows more details than I do about what our enforcement team's up to, but they're taking this seriously and they're looking
Yeah.
wide and far about who may be out there that should be registered that hasn't.
Because this seems like relatively a small number compared to what one would assume is out there, right, Liz?
Yeah,
Yeah.
I think, yeah, we think so. We think
Yeah.
so. So we know Mike's team's working on it and they've already brought, half a dozen, more actually, I think at this point, cases to try to get folks to, or matters to try to get folks to register. So it is certainly, on the agenda. And I think this year, now that, in addition to registration, they also have to do this big build, as the law requires, and then start deleting that. And with the deletion comes a different enforcement mechanism, because that's a deletion request under the CCPA. And so that is $200 per consumer per day, which is just a much higher fine. So.
Just one follow-up to that, because I know this is such an important part of the whole system working. And these dates are upon us. It's hard to believe that January 1st, 2026 is not far, right? You know that better than I do. But I'm wondering to what extent the industry, the data broker industry, is kind of advertising amongst its members, hey, you better get your act together and make sure you're registered, et cetera. Is that stuff happening that you're aware of?
I think so. We just spoke at the IAPP conference last week, and there was a lot of folks in attendance. People came up and they were in-house counsel or they were, outside counsel. We've talked to some of the ad broker industry groups. They're certainly aware. I think folks are really interested to see, what we're especially in terms of deletion, because it's that's not like as simple as registration, which is pretty simple. So, we plan to have a sandbox open so folks can come in the spring, and we have API documentation and stuff. So I think the industry is awaiting that. But I know, I think the folks in the ad broking space are pretty well aware. I think since the definition is wide, I think there are some folks who don't know, but we are doing the best we can to both promote and show up and teach and offer webinars and, try to, and then enforce so that people are paying attention.
I'd just add on to that. One thing we've really been promoting and really encourage any practitioners who are either representing a business or advising a business or in the business itself is to really look hard at our definition of data broker, because it talks about this idea of with whom you do not have a direct relationship. And we further define that in the regulations to really clarify it's a data specific issue. And so in terms of we recognize there's a situation where a business may have a direct relationship with a consumer in certain instances, but in other alternative instances does not, and is collecting and selling information outside of that direct relationship, which is an indirect relationship. So I really emphasize that because I suspect there are businesses out there who think because they have a consumer-facing practice that they are free and clear of meeting our data broker definition, and that just is not the case. So we're really trying to encourage people to look hard at that definition and think about their own data practices.
I think that's really important. I have a question that's a follow-up to Mr. Liebert's, but from the consumer side. And I know we've talked about this before, so please be patient with me. We always get to this in the afternoon, and this is my problem. The drop opens for consumers on January 1st, and it opens for data brokers on August 1st. And so there is a lag, which I think is understandable, so that data brokers can implement it and the system can be sort of tested with the consumers first. And I think this is something that Deputy Director Whitestrop is working to be sure that consumers understand. But I'm just attentive to the fact that information won't be deleted within 45 days for consumers for that period of time while we're waiting for the system to open to data brokers. And it seems that that's going to be pretty important for people to understand so that they don't, abandon ship and think that it isn't working for them. And I'm sure you're on it, but just wanted to check in, I guess.
Thank you for that question, Chair Urban. It's certainly something that we've talked about quite a bit, and that's why you might see in early January, February, March, we'll certainly be informing the public about DROP, but you're not going to really see our outreach efforts and paid advertising efforts really take full steam until March, because we don't want a whole bunch of people to sign up in January being confused that their deleted is
Yes.
not being deleted until even when the data brokers access it in August, then the 45 days, and then an additional 45 days before they have to delete. So just want to be really clear to the public, what they did is correct. It's just a timing thing with this first year.
Wonderful. Thank you so much, Ms. White. All right. We've interrupted you long enough. Please go ahead.
Okay, great. Let's go to the next slide. Okay, so I know you guys, board, you have seen this before, but just to kind of set up some table stakes here, we have essentially built, with the help of California Department of Technology, the DROP system, which is like essentially a CRM and a database. So we have consumers, and it's a double-sided platform. So on one side, we have consumers who are verifying their residency, coming in, giving us a small amount of information to submit a request. That goes into the system. Data brokers, of course, hit from the other side. They create account. They've done the registration in the system. They have paid through the system, through a third party that is connected to the system. And then they pull down their batch of deletion requests. The data brokers action those requests, write back a status, kind of was the record found and deleted? Was it exempt? Was it not found? Was it opted out? And then they report that status back into the system. And of course, consumers then can go check, once it's been 45 days, they can go check the status of their deletion requests. So yeah, and so essentially we're going to go through this with a bunch more details. We have actual pictures from the system, so you'll get to see screenshots from the system as it's built today, and we have a little video. So we're really excited to kind of show you where we are in terms of like actual product build and what folks are going to see come January 1st. So let's go to the next slide. Oh, do you want to do?
Sorry, I think we're going to start with the slides. Apologies.
Yeah, sorry, slides first, and then we'll go video. And thank you. Sorry, well, next slide.
Thank you. Yep. So now we'll go through, as was mentioned, we're going to start with the consumer experience. And I say that because if you think about it, there's actually going to be 3 entry points for this system. There's going to be consumers, the general public coming in to make the request. There's going to be registered data brokers coming in to make their account, maintain their account, process deletion requests. And then there's going to be staff, the administrative perspective. We won't be sharing that, that perspective today, but we will share both the consumer and the data broker experience. Next slide, please. So essentially, it is a 3-step process for a consumer. I know it says 4. I'll explain that in just a second. But in short, a consumer will come to our website, and the first thing they'll be asked to do before they submit their deletion request is to verify that they're a California resident. We have been partnering with the Department of Technology to leverage their sort of state-of-the-art identity gateway is what it's coined. And it's essentially a service for various systems throughout the state where individuals can have different elements of their identity verified. And then that signal comes back to the using department to then know that it can kind of extend the service to that person. So what's great about this system is that it means that verification process, our agency actually never sees any of that data. We just received the verification standard. And so this is a very, privacy forward, privacy thoughtful approach to how we verify and make sure information isn't spread too far unnecessarily. Specifically within the identity gateway, there are 2 vendors that can be, 2 choices that consumers will have to use. And I think we're actually going to show that in the next slide. So I'm getting ahead of myself a little bit. So step 2 will be, and we're going to show this in just a second, that the consumer will actually provide limited personal information about themselves. And we'll cover that in greater detail in just a moment. And then at the end, they click submit. And that essentially submits their request into the system to be picked up and processed by data brokers. But this 4th step that we'll show you as well is consumers, as they're interested, they're never required to return to the system. But if they're interested in coming back to check the status of their request or to add further details of their request, they can do so. Next slide, please. So here is a screenshot of one of the very first things you will see in the DROP system. it is to check your verification. And as you, oh, and one caveat I should make for all of this, for board members and those watching, everything you see is still subject to change. I have to play lawyer here and explain that this might get tweaked. Words may be different, layout may be slightly different, but generally speaking, this is what the product currently looks like, essentially. The consumer will start by verifying their identity, and they'll have a choice. Their residency, sorry. So their choice will be to either use login.gov, which is a federal program that many consumers, many Californians may already have accounts for. And if they already have an account for that, this will be a very easy way to log into your existing account, verify your residency, and then come back into the drop system very quickly. They would also have the option to create a login.gov account for that verification purpose, but they're not required to. In the alternative, they can use this other sort of personal information based verification through the Identity Gateway, which CDT has stood up in partnership with an entity called Socure. Next slide, please. Yeah.
Did you want to catch the name? I did.
Oh, no, I just wanted to ask a quick question.
Please go ahead.
So let's going back to that prior slide, right? No, we're on the right slide. I've got it. So sorry. So Elon Musk is in charge of login.gov, correct?
I believe we all have the same question, perhaps.
Who's running login.gov? The federal government right now?
The federal government, the General Services Administration.
Okay. And then the other entity that you're mentioning is a private entity in, where is it located and how did you come up upon that? Because one of the things that's going to be of concern to consumers right now, particularly in California, no surprise, is this whole safety of their information issue, ironically, as we're dealing with the DELETE Act, right?
Yeah, excellent questions. I mean, I'll...
And just a bit, I believe Ms. Hamer asked a similar question. Tell me if I'm wrong. Last time about login.gov, and I have a similar question. So that's why I said, well, those of us at least are here in person. I think this is of deep importance to us.
Yeah, these are great questions. I mean, and there's a number of things I want to say in response to that. I'll begin by just saying, part of the idea of the Identity Gateway is choice, consumer choice, to choose which verification tool that a consumer is most comfortable with. So we understand some may have biases against one version or the other, and we recognize for a variety of reasons. And so there is consumer choice on which option they would want to use for this verification purpose. Another thing to share is the way verification services generally work is that they've already amassed information on consumers using these systems to verify information about themselves. A lot of information, I'll just put it that way. And they leverage other databases already with information collected on these consumers to then verify against what a consumer coming into the system is saying is true about themselves. So in some regard, yes, they will have to put up some personal information, but it's being compared with personal information both services already hold on the consumers. I know that may be of little comfort to this board, but at the same time, I'll just acknowledge in terms of how this is actually working in practice, this is not sort of new information necessarily to these organizations that are conducting the verification. Let's see, beyond that, you asked about Socure. I will just say this is a partnership first established with the Department of Technology. The Identity Gateway has been established sort of with security and privacy as sort of a paramount function. And so these contracts are also pursuant to our state security standards and are overseen by our state's, Department of Technology and their security teams as well. So we do have trust in our partner department and sort of their ability to kind of monitor and control their contractors in this regard.
Yeah, I think we mentioned in the last board meeting, but also on to add that the Identity Gateway is for the whole state. So there's other, agencies that use the Identity Gateway. This is that. So when you go in, you're using California Department of Technology's group and identity verification group, and that group is available for the whole state. So this is not an independent contract between CCPA
and that's if you click on the Use Personal Information Gateway.
Yes,
as
correct.
opposed to if you use login.gov, you're going through the federal government's gateway.
Yeah.
Got it.
But just, yeah, and, you know, login.gov for folks who have social security, et cetera, you know, there's nearly a third of Americans already have an account there. So perhaps they feel more comfortable verifying, you know, with their account they already have rather than giving away more information. You know, we just don't know. So I think optionality and education is like the best, you know, the best we can do for folks.
Very good questions. All right. So once you do cross that verification hurdle, and we've confirmed it's a California resident, and to be clear too, we also thought the verification component is an important component of this system in the sense that we do have a responsibility as the state also to not put forward, you know, fraudulent non-resident requests to data brokers when really the purview and scope of this system is for Californians.
And we don't want to hold everyone's, you know, driver's licenses or whatever, right? Like, yeah.
All right, next slide, please. So then step 2, they're going to provide limited personal information I've been seeing. And again, this is a screenshot from the system. So you can see right off the bat, you'll have the opportunity to enter first and last name. I think we're going to show a few more screenshots of this page. And in a minute, I'm going to show you a video that actually shows this happening at once, because I know it's kind of hard to visualize through screenshots. So I'll move quickly through these next few slides and just say, with names in virtually every category except date of birth, you'll be able to add up to 10 additional versions of that. So a name, we understand there may be maiden names, nicknames, changed names. So recognizing there's different situations where you may want to represent different aspects of yourself or different versions of your identity. Date of birth is the only one we're not going to allow you to try to enter multiple versions of. Next slide, please. So as you see now, date of birth, zip code. One of the sort of assessments we made early on was that getting a full address was actually not necessary. And so in sort of an effort to practice some data minimization with the system and kind of key off just the right amount of personal information to reasonably identify a person, we only needed zip codes. Again, you can add up to 10 of those though, recognizing people may move, you know, in the course of their life. And then with email address and phone number, I'll notice a feature you're going to see in a moment, and you'll see a button that says verify next to that. Again, a bit as a fraud prevention measure in this system, consumers are going to be required to actually verify through a multi-factor authentication that they have control of either that phone number or that email address. So this is very much like a system you may be familiar with where you get a text with a code that you have to then input, and then it shows, okay, this person actually holds that phone number.
I think we have a question from Ms. Hamer.
Yeah. What about the situation where somebody had been related to an email, but they no longer have control over it? And there's a lot of information that has been gleaned through that email process.
Yeah, that's a really great question. That is something that was a scenario we definitely thought long and hard about, and we recognize is still something we'd like to try to address in the future. Just to be frank, I think in the interest of getting this product across the finish line for our deadline, we recognized there wasn't a way to adequately verify and show control over past email addresses in that same regard. So right now, the system wouldn't be able to accommodate that scenario, but we are hopeful that it's something we can improve upon in future iterations.
Okay.
The other thing I'll note is, as I'm going to explain in a little bit, these identifiers essentially all go into feeding deletion requests. And I say that because in your example, perhaps there's an old email address associated with a lot of personal information on you. Well, if it's any of these other identifiers and you were matched on one of those other identifiers with that same data broker, it'll still then result in a deletion for your information, if that makes sense. I recognize there may be scenarios where the only identifier associated with your profile is that expired email address. But in the event that expired email address also happened to be associated with a phone number that you do still have control over and you enter, that's just going to be another way in which a data broker will still be required to delete your information, because they're supposed to pull all the information in lists. And this is going to make more sense when we show you the screenshots that reflect the types of databases they have and the types of personal information they collect.
Got it. I'm thinking specific use cases. Somebody sells their company, their email goes with the new company, and that email probably was used for maybe a decade, you know, on other things.
Yeah.
But it's going to be a challenge on that one part, but you're going to look at it later.
Absolutely. Yeah. Again, I think you're hitting the nail on the head of, you know, kind of the difficult but important trade-offs we were having to consider in how we did the initial construction of this. But, sort of getting further, more and more edge cases still brought into this is definitely our goal. So what we're describing now is,
One thing
minimum
too.
viable product.
Yeah, I just want to state one thing, not just for the board, but for the public, because we heard a bunch of these questions at IAPP at the conference we're at, which is like, if you, as a consumer, you might give 20 pieces of information, so you give 5 email addresses, 2 phones, whatever. Those 20 pieces of information are just trying to find the one string of 1,000 data points they have on you. So any one of those 20 could match, or all 20 could match the 1,000 data points the data broker has. And they have to delete all non-exempt information, no matter how they match it. If they match it off your name, date of birth, and zip, or if they match it off your email, it's not that they're just deleting the one email. They're just using it to find you, and then they have to delete everything. And so we've heard some confusion where people are like, oh, if I match an email, they just delete the email, but that's not how it works. That's not how the law works. The law works, you find, and then you delete everything. So the more information you get, you have 20 shots, if you enter 20 pieces of data. If you enter 40, you'll have 40 chances. And because some data brokers hold 2,000 pieces of data and some only hold, 10, and some data lists are older and, cleaner or less clean in terms of their database, your hit rate will be different. But that's just also, the way the laws are written is that it's not just the piece of data, it's the whole string.
All right, next slide, please. And then you'll see beyond those more common pieces of personal information, we are aware of other common types of identifiers that data brokers deal in a lot and collect on and track on, that consumers may have access to, may have knowledge of, may not, but that they have the option to input as well. An important one being a mobile advertising ID, which can be connected to your device. Another option is your connected television ID, which can be connected to your television, your smart TV, or your vehicle identification number, your VIN number, essentially connected with your vehicle. These will be optional as well, like all data points in this system. And we do plan to do a lot of education on these more sort of nuanced and less obvious data points on consumers, including education about how to find your maid on your device, for instance. So we recognize not every consumer will be immediately versed in these things. And so we do plan to do some education on that topic. But again, we recognize this will capture some of those edge cases, or maybe not so much edge cases, where actually the only thing associated with that consumer is their maid, for instance.
I believe we have a question from Mr. McTaggart.
Yes.
Please go ahead, Mr. McTaggart. You're on mute.
Yeah. And you just touched on it right at the end there, Mr. Laird, but what would be super helpful, I don't know where you're, rather than just education, sometimes if you're on some sites, like you might actually have a link. If you have an iPhone, click here to figure out where your, maid is. If you have an Android, Samsung, whatever. And then same thing for the TV. Like that might be really useful to take you to like a page that said, because I'd love to do that, but I mean, it would probably take me however long to find out where the TV ID is, that kind of thing.
Absolutely. That's our hope, is to make it as streamlined as possible so people can find it quickly. We're also hopeful that some of our partners who are watching the system and wanting to support its success will also promote this kind of information to help consumers use the system.
361, maybe.
Yeah.
I might have missed your question, Mr. McTaggart. The little question mark after the MAID, I just went to my iPhone to try to find MAID and I didn't. But I'm sure it's there because I know if I went to talk to Tom, he'd show me how to find it. But I'm thinking about being that 70-year-old consumer that someone referred to on the phone today, or someone else did. And is that question mark going to tell me and that person how to go find the maid, or?
Yes, that's the concept, is with each of those, we're not going to ever assume, everybody has the same privacy and technological knowledge that the rest of staff does. And
so it'll be easily understood instructions. You want to go find it, it's right there.
Yeah, we call it just-in-time information in these designs, where essentially as the consumer comes to it and says, well, what is that? They'll have the opportunity right there to learn and not have to navigate all over the website or something.
Yeah.
By the way, Mr. Liebert, thank you. I'm blind. I didn't see I wasn't focusing on the question mark.
Well, the question mark is just a question mark. So I think the question stands.
I didn't show you the screenshot of where it links to, in all fairness. So yes, but it will have a link.
And just reminding everyone that 361 also requires data brokers to report which one of the main identifiers they collect, and if they don't, to tell us what else they collect, so we can continue to kind of iterate to help folks make matches. You know, data broker industry is vast, and they, you know, lots of different types of data brokers out there, and they collect different pieces of personal information. So as Phil has mentioned, we do expect to iterate, and 361 will also help us do that.
Thank you.
All right. Next slide, please. All right, so after you've navigated through all of those and added the information you wanted to, you'll hit submit, and voila, you have successfully submitted your drop deletion request. You will then be issued a drop ID. Please do not be scared of the very lengthy drop ID in this screenshot. It will be much shorter, we promise everyone. Much easier to remember or record, I promise. And I can explain that feature in a moment. Well, I'll explain it now. Essentially, you'll have two options then after you've left the system, and that is you can always re-verify who you are, come back into your profile page, add and subtract information about yourself, and see a detailed explanation of how your deletion request is being processed by data brokers. But if all you want to see is get a snapshot sense of what's happening, how many data brokers have processed, how many deleted information versus didn't find information, that drop ID will be something you can just enter on a separate page and immediately get that readout. So it's a very convenient tool for consumers who just quickly want to get that information and not necessarily re-enter the whole verification process to get access quickly to that information. In addition, it's not displayed in this screenshot. You will have the opportunity to enter your email address to email yourself this confirmation page so you don't forget your drop ID, and also to sign up for both the agency's newsletter as well as then drop specific updates, which we don't anticipate issuing information on too much to email addresses. But for instance, if we ever start accepting a new form of identification or something, we can inform consumers so that they can update their profiles. Next slide, please. Another feature, and this goes a little bit out of order because this is something you can actually access before you submit your request, but it's also certainly something you can update after you've submitted it as well. You'll actually be able to open up and look data broker by data broker and decide, and this is the checklist we discussed earlier, if there are data brokers that you don't want to have receive your deletion requests, and essentially allow them to continue processing, collecting, and selling your personal information. But at the bottom is the checkbox that we discussed earlier, Chair Urban, and that is, it includes future data brokers. And that means that for those wanting to use the system who decide all data brokers should receive my request and I don't really want to have to return and check every time a new data broker is added, they could select that, and essentially their request will continue to get submitted as those data brokers come into the system.
So that's even simpler than my logic-based approach.
Yes.
Which was your intention must have been to also include the brokers who hadn't registered, but they will have said this directly by including all future data brokers.
Precisely.
Perfect,
Precisely.
thank you.
All right, next slide, please. And this gives you a little visual then of what it'll look like to see your status. You'll kind of get this very quick readout of how many data brokers are registered in the system and what your status is. There are 4 status, well, there's pending, which just means it hasn't been processed yet. And then there's 4 statuses that a data broker might report back. One is that they deleted your information, and that means they found a match, you were the only match, and so they deleted all of your associated personal information. Although I'll note, it still indicates it does not indicate if they held exempt information. So they may have deleted everything that's not exempt, but there may be certain information. Actually, no, scratch that. It does indicate that they deleted everything. It's the next status, the exempt status, that would indicate that they have a match for you, but that all information they have about you is exempted under the law in some capacity, and therefore they are recognizing that you were in their system, but they did not actually delete information in regards to you. Another status they might report is that they've opted you out of sale or sharing. And this is a scenario where the data broker has said, essentially, you know, for instance, your phone number. We see your phone number, but it's associated with actually 3 different consumers, not just you. In that situation, our regulations require that the data broker opt all 3 consumers out of the sale and sharing of their personal information in lieu of the deletion requirement. And this is because essentially the data broker is saying we could not confirm in our own data that you are the person associated with this, but there's still a requirement of the law that they still be opt out of sale and sharing, even if they can't be verified.
That prompts a question for me based on your example, which you may not know the answer to. How then will family phone services be treated, or indeed phone services where individual family members have individual phone numbers, but there's one account?
That's a good question. The latter, I think, is a little trickier. I mean, again, with the phone number, at least, if it's a phone number only and there are multiple consumers, it's what I described in terms of they will all be opted out of the sale
Right.
sharing if associated. I guess the only other thing I'd offer is, or just kind of reminder, is that, as Ms. Allen described earlier, if you've entered other pieces of information, though, and there is a match for a deletion,
Sure.
for instance, on your email, that's going to override the opt-out associated with
Sure.
the telephone, if that makes sense.
It does.
Yeah.
Yeah.
But also, like, the account won't matter. So you could be a family account with 13 lines, but you know, if each one of those 13 people go in, create a drop request, verify their phone number,
It goes to the number.
it'll go through to the number.
Okay.
Yeah.
All right, great. Thank you. Because they always ask for the cell phone number. And I think it's pretty typical to have like a family account with a number of
With many,
separate
yeah.
lines. Sure.
Totally.
Yes. I mean, yeah, we're all pointing.
Yeah.
Applies to all of us. Personal, applies to many of us. So, you know, personal question to some degree. All right.
Yeah.
Thank you. Thanks for both of you. to both of you.
Briefly, Chair Urban, I just wanted to make you aware that Board Member McTaggart has left the meeting.
Okay, that's fine. Just as a note, we have 3 board members, so we still have a quorum in case we need to take another vote. Thank you. Please go ahead.
And then the last status is record not found. And this is simply based on the information that was provided by the consumer. There was not a match within the data broker's own records. And therefore, we would presume at least that they don't collect information on that consumer, but it could also be indicative of just maybe different spelling potentially, or even more broadly, just not the right type of information was entered based on what that data broker collects on their end. Let's see, next slide. I think this is going to be time for, yeah, I think we're ready for the video. And so the video is going to be everything I just talked to you about, minus the status check. But in real-time demonstration, I'll give a little bit of narration over it. But really, this is just, again, I know screenshots don't really tell the story. So seeing what you'll feel like as you're scrolling through this website, I think is really helpful. All right, so this is actually playing. You scroll down, you see it's essentially a list of the same identifying information I showed. We're also demonstrating how there's some information for anybody who you're assisting submit a request for, and those are some instructions you would see. You see now the person using the system is putting in multiple names and that they're able to add as well as remove if they wanted to. This is demonstrating you get one date of birth. Again, here are some zip codes and demonstrating that you can easily add additional zip codes. So this is then you going through the multi-factor authentication experience for an email address. And so the request was submitted to the email address, and now the individual is prompted for that verification code. Our screen actor, by the way, is our chief of IT, Art Andrusov, to his credit. And then once again, you can add additional email addresses that you can verify.
Now, do you have to add an email address and a phone number, or you just have to add what you've got?
Whatever you have. Yeah, exactly. It's a very user choice based system.
Yeah. So you could do just an email, or you could do, just a maid with a name.
And then you'll notice too, for phone numbers, you can choose both your country code as well as you can choose whether to call or text, because we understand the landline wouldn't have a text option for verification codes.
That was what I was wondering about, so I'm really happy to hear about that.
And then finally, if you're submitting on behalf of somebody else and you check that box, it is required in our regulations that their name and business association, if they are sort of a company type of authorized agent, be provided as well. And then you get to see all your information before you hit submit. And once you hit submit, then it's that page where you're telling you about confirmation. You'll even get an opportunity to rate your experience, because obviously we want to make sure this is we are serving consumers and are going to be listening and reactive to what consumer experience is like for the system.
That's just a little hint there.
And then finally, you see that final status page. And so right now, if there was only 4 data brokers in the system, you'd see 4. You could click on each status to see the specific list of which data brokers didn't have information on you versus deleted your information. And this is demonstrating that data broker functionality and how you can actually update your list then at some point to decide you want to either add or subtract a data broker from your deletion request. Here is then the drop ID that we mentioned. And again, it'll be only 8 to 10 digits, I promise. And you'll get the summary view.
And now we're watching re-verifying the residency?
I think this is actually restarted. I suspect this is restarted now.
Okay.
We could probably
I just noticed that at the end, it had a little note about re-verifying residency. I believe you don't have to do that in order to see the donut.
That's exactly right. Yes, great term. So to see the donut, as I mentioned, you can look at this version that's actually on the screen right now conveniently. And the point here is this is just an aggregate set of information that doesn't tell you anything about the details of what was in that request or which data brokers did which. If you want to get to that extra level of information or update your request, then you could re-enter the full system by verifying your residency. So essentially there's the light status check, and then right at the bottom, you'll have the option, if you're curious, to go do a more in-depth status check.
And that will send you back to the interface that shows you each data broker and the status and whether you opted out. Mr. Liebert.
So when we talked earlier about terms of service and privacy policies, and you've got to click accept if you want the service. This strikes me that many consumers may wonder, what's going to happen to me if I delete all these data brokers? And there's nothing on this site, of course, that's educating them about, this is what this will potentially do. So I'm just wondering, how do we deal with that uncertainty, right? The uncertainty.
Great questions, and we've already addressed it. I'll assure
great.
you.
Sorry, I'm always asking the ones that, yeah.
This is to say, one thing that wasn't demonstrated, actually, before you even verify your residency, you will get a terms of service little pop-up here that does explain a little bit for the consumer of, what the system is intended for, what will happen with your information when you delete it. So lots of that information, but we recognize anything named terms of service, some people may glaze over or not pay much attention to. So what I'd also assure you is this application will live on a web page on our privacy.ca.gov website that's going to be full of information. And of course, one of the things people might do right away is click the start my deletion process. But on that page is going to be as much information really as a consumer wants to learn about this topic, including what types of personal information data brokers collect on them, how they collect that information, and then importantly, how deletion works and what it will do with their information.
So I guess what I'm alluding to is a concern that you might be losing some benefit by saying, get rid of all my personal information. Is there any way to address that issue? I don't know that there is, but I'm just wondering because I think consumers will wonder about that.
Did you want to comment, Executive Director?
Do you want to direct? Okay. Well, so a couple things. I think, so part of the challenge of all of this is describing what a data broker is, right? And how this is, what we're trying to allow them to delete, what they are allowed to delete under this law is like not first party data, right? So this is not the shoes, this is not the Spotify algorithm, this is not your Netflix algorithm, this is, the information and then the inferences from third party data. And that's what we're trying to get to. And so that's a hard thing to, you have to figure out how to teach people what a data broker is, and then that there is a level of safety because this is not the treasured Netflix algorithm or the hard fought, first party data. So I think what you're talking about is that is tricky. We do have privacy.ca.gov/drop where we're going to put in a lot of information, including the history of privacy and the history of Delete Act and all this stuff. And I think I think there is, if you are someone who loves a big stan of targeted advertising, and that's, I think there is, in reality, some of that will go away or it will be less. Now, I guess that's just something that, that's what we would educate on as well. It's like, hey, we're not talking about, I don't know, for example, Amazon knows the diapers that I buy my children or whatever, it's not that is not what's getting touched by the Delete Act. This is third-party data.
Yeah, I
So-
don't know if there's a way to deal with it on the website in terms of education, but I do think that is one of the major issues that anyone will have in the initial
They're
interface.
scared. They're going to be scared, right?
Right, yeah, it's like, okay, I know I want to get rid of a lot of this, but I still want Netflix or whatever the deal is. So how you educate on that issue, maybe through examples, it seems to me that cries out for just some examples of things that could happen, but things that would not happen, would be a source of reassurance for folks who actually want to take advantage of this system.
I agree, and I think there's the possibility that people would also worry about things that are a little bit more fundamental. So will I not have a history for a rental application check? And that kind of thing.
Right. Yeah, will my identity not be able to be verified, and it's like,
Yeah.
no, and of course the exemptions and there's.
Maybe
hard to-
FAQ, maybe an FAQs type thing or something like that could help address those types of nagging things, am I still going to get that medical alert or whatever the deal is? Yeah.
Yeah.
We're absolutely planning. We're absolutely planning an FAQ portion of the page, sort of descriptions on data brokers on what happens when you get your information deleted. And but this is excellent feedback, and of course, anything more we can do to sort of promote those ideas or ideas that are maybe missing from the website that you think should be communicated, we'll be happy to continue to iterate on.
Yeah, I was going to say that what you see now is V1, and we are working actually actively right now and have been for weeks on building out a much more rigorous consumer facing section of the drop, and we will continue to add certainly over the year. So.
All right. So with that, I think we're ready to move back to the presentation and show you just a little bit about the data broker experience, because obviously for 500 plus businesses out there, this will be a system they have to use and pay careful attention to. And Liz is going to present this side.
Yeah, sure. So you can go ahead, next slide. Perfect. Okay, so the data broker flow is a little bit more complicated because they have more obligations under the law. So there's about 7 steps that they have to go through. First, they're creating an account with Drop, and they'll have to complete the registration and complete payment within that account. After they have done those 2 things, they'll have access to our deletion requests. Within their data set, do they have emails? Do they have phone numbers? Some data brokers don't collect them because of the do not call list, for example. So if they don't have phone numbers and they don't collect them, they won't pull that list. So they choose the list of identifiers. Maybe they want just maids because that's all they have, and they don't collect the other stuff. So they choose their list. They download every 45 days as required by law. They could do it every day, but they could also do it every 45. They can choose their whatever they would like to do in terms of timing for that. Download the list, and then they, on the back end, will have to match to see if any of those identifiers provided match with somebody in their own system. They, of course, have to delete the entire record of any information they have that is non-exempt under the law. And then they have to maintain what most people call a suppression list, which is essentially a list where if they're buying new data, they'll check to make sure anyone who's submitted a deletion request, like the data doesn't come back into their system. So they have to maintain that person as deleted, meaning keep them out of the system, even if they're inputting new data sets. And then, of course, as we talked about, they have to report the status so that the consumers can come back and check the status and see which of those 4 statuses they got. So go ahead and we're going to run through this. So go ahead, next slide. All right, so first, when they first land on the page, in the application, the web app, they are going to have to create an account. All of this is required in our regulations, and actually is very similar to what we required last year in the registration form. This won't be very new to them. They, of course, have their public-facing contact and then internal contacts for the agency. Okay, next slide. Once they submit an account, actually the internal agency staff will verify, make sure these are real accounts, real people, real businesses, and we will approve their account. Once the account has been approved, they of course can, in January, well, throughout 2026, but obviously January 1st through 31st, they'll need to complete the registration form if they were brokering data in 2025. You can see it's about 10 steppers. So they review their account information and then they go through all the required disclosures from 361 or 362 and then this year's 361. So this will be very similar to what they did last year, but just adding the 361 requirements. Next slide. Okay, great. So once they've paid, this year, of course, the fee is $6,000. We have an external payment vendor, so they'll be routed out for a second to the vendor, pay with credit card, and come back. Once they come back, they will be considered registered, and that will open up this dashboard. Now, the dashboard's actually a bit longer than this, but you'll see it'll kind of show them when they registered. It'll have the receipt, of course, payments. Imagine 5 years from now, they can see all the registration payments, how many records they are downloading on their lists, and then you'll see that consumer deletion lists. So at the very bottom of that box, you see view or change lists, and that's where our 6 lists will be, and they can choose, just made, perhaps if that's all they have, or, just VIN if that's what they have. However, if they have maids and VINs and emails, they choose all 3 lists, and they can download them. So once they've chosen their list, let's go to the next slide. They can either choose to download those lists manually. So that's like, essentially getting various CSVs and downloading the CSVs via our manual download option, or they can connect via API. And so an API, of course, is an automated pull and download. So they'll get an API key. They'll do a little bit of back-end engineering to connect to our API, to integrate with our API, and then they'll be able to pull their lists through the API. So if they've got, an API key, they can essentially set stuff up and make sure they're pulling down correctly. Okay, next slide. Okay, so then once they've got their lists in-house or in their own system, the lists, of course, are hashed on our end. We're using the SHA-256 hash, and we are not keeping any data in plain text in our database. And so we will be providing the lists in hashed form. So all the emails will be hashed, and they will, of course, have to take those hashes, take all the emails in their system and hash, and then try to match the hashes. If they come up with a match, that, of course, is record found. If they have a hash that doesn't match at all, that would be, of course, they would return record not found. And then, of course, they're deleting the record, and then they have to create a suppression list. We don't dictate how folks need to do that. A bunch of companies already have suppression lists, and they have their own systems. So the expectation is more that the data that they maintain as deleted in a proper form, and that the consumer doesn't come back into the database if they have been deleted. And then, of course, they need to report the deletion status within 45 days. So they can report sooner if they want, but they must report within 45 days, and they can do that either manually or via the API. Next slide. Okay. So, well, I guess, do we have questions on the data broker side of things before we go to timeline for launch?
Mr. Liebert and Ms. Hamer. So, Mr. Liebert, go ahead.
Mine's just quick. It seems like it would be pretty difficult on the enforcement side when they say, we only have these identifiers for a list? How do we know if they're telling the truth?
Yeah. So we don't.
Okay.
We're not going to know. However, they have a legal obligation. We do have enforcement with technologists who will be able to kind of work with the company if there's an investigation. We also have this audit. It's one of the reasons the audit's really important. In 2028, they'll have to have an independent auditor come in to ensure that they are
Okay.
complying with the law. And so you'll see our regs we'll be working on this year. We're going to do preliminary comment around them, trying to figure out exactly how we can best capture that. How can they demonstrate that to us, especially folks who are doing a great job? Like,
Right.
show off,
Right.
please, tell us that you're doing it. And so those are like the levers that we have at this point. Great. And then, of course, consumers can file complaints. So if they're like, hey, we've got, I know I put in a deletion request. I know I went back in, this company's on the list, and I'm still seeing my data here on their website because I went to the registry and I know all their, the websites, they can file a complaint with the agency.
So the auditing process could really help there too, yeah.
Yeah.
Okay.
Yeah. So hopefully consumers and auditing, and, we had talked about a whistleblower bill, there's other things as well.
Wonderful. Thank you.
Yeah.
Ms. Hamer?
That was actually one of my questions. And then the other one is just confirming I've got the math right, that the earliest people are going to see the results of this will be basically a year from now.
Yeah, that's a great point. I mean, I think our hope is actually to allow data brokers to voluntarily start processing these requests earlier than August 1st, because as you can imagine, having all 500 start entering the system and doing everything at the same time may not be a great recipe for success. So in some regard, you may see it much sooner to some extent. But for those that are registered as of August 1st, we've done the math that it could be as late October before they've gone through the cycle of pulling the data when they had to and reporting back the status of what they did before you see all 500 plus data brokers give you one of those statuses.
So it's about 90 days from August 1st.
That's exactly right.
Because we know data brokers are going to want to delete everything early.
Yeah. So we'll be opening a sandbox in the spring where folks can, start working on connecting, and, and some folks have said they will start doing, taking action early, but truly October. Yeah.
So before we get into the timeline, I have a very technical and legally complicated comment, which is, this is pretty darn slick. And I'm really proud of the team. The historic team with Executive Director Sultani, the current team led by Executive Director Kemp, everybody who's helping us out at the Department of Technology, and all of our folks who aren't here today. This is just really well thought out, and obviously we've been kicking the tires quite a bit, which is appropriate, but it's pretty darn slick.
I have to echo that, because every time I tell somebody that we're doing this, they get so excited and they want to do it right away. And I'm like, that's why I asked the timing question. So I've got that right.
Yeah.
Yeah, and I'll just do a special shout out to Mr. Kemp, who worked amazing work in the California legislatures that's underscoring all of this now. And it's just, it's really exciting.
Can I take a slight detour, which I think is in line with the agenda item, Mr. Laird?
Sure.
I know there has been some appetite, at least from other states, to maybe piggyback off of this. This occurred to me in part because of the legislation side of it, when Mr. Liebert mentioned Mr. Kemp's efforts there, but also, of course, the system itself. And I don't expect you to have an update today, but I would love to hear about that at some point.
Yeah, I think right now I'll say we've certainly heard interest from other states and other legislators in other states in this. There is not currently another law that implements a similar system yet, but at the same time, we are happy to share our insights and are exploring sort of all options in terms of how other states, if they want to leverage our system or copy our system, we want to be supportive however we can.
And could we rent this out for a very large fee?
It's not out of the question, or at least a reasonable fee.
We can all go to the Global Privacy Assembly.
He's joking.
I won't drag everybody to the Global Privacy Assembly. Yes, I'm joking.
Yeah, I also just wanted to say we've also been working with UX designers on this. So some of the slickness that you see is also a very talented UX team over in CDT. So just want to give them an official shout out for making it as beautiful and seamless as it is.
Excellent. Thank you.
I think for our last few slides, yeah, again, I think we've been over the timeline enough now.
Yeah.
You probably get it. Do you have it yet? No, with that said, though, this is just about 2026, right? So again, so everybody's clear, January 1st, you'll be able to log in and create an account and make your first submission for consumers. Same time, data brokers need to come into this system to register. This is very important. Registration looks a little different this year because you'll create an account. It won't be the Microsoft web form that we've used the past 2 years. So the process looks a little different, but the same information plus the SB 361 requirements will be included. And then, as was mentioned, we'll be allowing data brokers to come in and start testing with the system in the spring, and then allow processing of actual deletion requests a little after that. But officially, that obligation begins August 1st.
So if I may, it begs the question on the advertising front. I can't believe January 1st is so close, and you're saying consumers can start submitting deletion requests. So we need to be getting the word out pretty quickly. So at some point, you're going to tell us the ways in which we're going to educate consumers about that.
Yeah, I mean, I think Ms. White has covered that in past presentations a little bit, and again, as alluded to, we are balancing, though, that fact of we're excited, we want to get every consumer through the door, but we're trying to really acknowledge a consumer who's not hyper-focused on this and comes into this in January and then doesn't potentially see anything happen with their request for months might be a frustrating experience. And so we don't want to sour anybody to this system as that result either. So we're balancing those interests. And I think, as Ms. White mentioned, I think you'll see promotion ramp up as we come closer to August 1st.
Got it.
So that people will come into the system, we'll have worked out the kinks, and we'll have a very seamless experience come the fall.
But they will see it on our website.
Absolutely.
Yeah,
Yeah.
exactly.
We won't be hiding the fact that
Right.
it's out there. It just may be more broadly promoted later in the year.
Got it.
Yeah.
Thank you so much. Are there public comments on this item?
All right, this is for agenda item number 5, the drop update and presentation. If you'd like to make a comment at this time, please raise your hand using the raise hand feature or by pressing *9 if you're joining us by phone. This is for agenda item number 5. Jacob Brent, I'm going to unmute you at this time. You will have 3 minutes. Go ahead and start when you're ready.
Good afternoon, everybody. I'll keep it quick because my issue was partially addressed during the conversation. So I represent the California Retailers Association, and I'm reaching out on behalf of some of our members with concerns regarding the current presentation of information on the DROP webpage. So there's currently a FAQ styled section, and on it, there's an area titled Why Submit a Drop Request. And we feel that this specific area emphasizes consumer control, but doesn't acknowledge that deletion of certain data could impact access to personalized services and customer experiences. So I know this was already discussed a little bit, but we just wanted to emphasize that we really feel like the effects from the deletion of data should also be at the forefront. So we want to respectfully request that this section be revised to reflect a more neutral tone and include context about how data supports service delivery. So that is all. Thank you very much.
Thank you for your comments. Again, for agenda number 5, we're taking public comment. If you'd like to make a comment at this time, please raise your hand using the raised hand feature or by pressing *9. Madam Chair, I'm not seeing any. Oh, we have another commenter. David, go ahead and speak. You'll have 3 minutes. Begin when you're ready.
Thank you. I appreciate it. I wanted to ask about authorized agents. If I pay for a company to be removing my data, I saw that there was a form to fill that out where you can add the company or the ID, but for the end consumer, how does that work? And you also mentioned the API configuration between the data broker and the drop system. Is that something that's also going to be available to companies that use authorized agents to process these requests? And in addition to that, for the residency verification? Is there something that an authorized agent would need to provide to prove that that person lives there, or that they're authorized to make that request on their behalf? Thank you.
Thank you for your comment. Again, we're taking public comment for agenda item number 5. Please raise your hand using the raise hand feature or by pressing *9 if you're joining us by phone. Okay, Madam Chair, I'm not seeing any additional hands raised at this time.
Thank you. Mr. Laird, would you like to address the questions?
Yeah, I'd be happy to.
Questions, we didn't ask them.
Yeah, absolutely. So the law does require that the system allow for an authorized agent to assist with the deletion request, but at the same time, we're balancing sort of verification and sort of consumer assurance aspects of this. So one component of our regulations actually required that the consumer for whom the request is being made is the consumer who is verified at the time of entering the system. So that's an important component. Now, an authorized agent is allowed to assist with everything following that process, but the expectation is that the consumer would still verify themselves and verify their residency before they receive that assistance. So at this point in time, there's not necessarily an API option for sort of a enterprise-wide authorized agent who's maybe representing multiple consumers to directly enter the system. It's something we thought a lot about and would like to continue to explore in future iterations. But again, at this time, there wasn't quite the ability to achieve sort of that option in this current framework.
Thank you very much. And thank you for the comments and the questions. With that, I think I will sum up the sentiment that has been presented today, which is that we are incredibly excited to see this come to fruition and are really delighted by and proud of the both creative, technically careful, and privacy careful work of the team in putting this together. So kudos, and we'll look forward to updates when you have them. With that, we'll turn to agenda item number 6, which will also be presented by Mr. Laird and Ms. Allen. And it's an update and possible action on proposed amendments to regulations 7601 to 7604 and adoption of regulation sections 7610 to 7622, implementing the drop requirements, including possible adoption or modification of text. So these are the regulations we've discussed in board meetings several times that are the required regulations sort of underpinning some of the design decisions and the way that consumers and data brokers will be able to interact with the system that are required, as well as the technical development. And I will hand it over to the team.
Thank you, Chair Urban. Admittedly, this was another instance where the timing with Office of Administrative Law review was such that we didn't know at the time of when we were required to post this agenda 10 days ago whether or not the package would be approved or if there might be issues we need to resolve. And so we put this on the agenda to sort of allow us the ability to further discuss if there were issues identified by the Office of Administrative Law. And I am delighted to share that there were not issues identified by the Office of Administrative Law. And in fact, yesterday, this package was approved and filed with the Secretary of State. So that means the regulations that you all approved and adopted at your last meeting on this topic will now officially take effect January 1st, 2026. Right on time for drops deployment.
Wonderful. That is terrific news. Thank you. And thank you again for the incredibly competent rule writing and shepherding by the legal division and Ms. Allen. I'm glad the Office of Administrative Law seems happy with us. That's important.
We're 3 for 3.
3 for 3. Okay, let's not jinx it. Let's not jinx it, but yes, but that's terrific. That's absolutely terrific news. I think with your permission, Mr. Laird, I will treat this as an announcement and move on to agenda item number 7.
Yes, that would be
Wonderful.
fine.
Thank you. Congratulations and thank you both.
I will say, at abundance of caution, we should probably offer public comment, though.
Oh, okay. Is there public comments on this item?
Okay, this is for item number 6, update and possible action on proposed amendments to Regulation Sections 7601, 7604, and adoption of Regulation Sections 7610 through 7622, implementing the drop requirements, including possible adoption or modification of text. All right. Please raise your hand using the raise hand feature if you're joining us by Zoom, or press *9 if you would like to make a comment and are joining us by phone. Madam Chair, I'm not seeing any hands raised at this time.
Thank you very much. And now let's move to agenda item number 7. Agenda item number 7 is a discussion of the 2026 board meeting calendar. It will be presented by our Deputy Director of Public and External Affairs, Ms. Megan White, whom we've already put on the spot a couple of times today, and she handled gracefully, as always. Just to give a little bit of background on this item, we do have a standardized quarterly meeting agenda with standardized items that are on this calendar in a regularized fashion. Sometimes we move them around, but we do need to give some attention to when we will schedule those meetings, and Ms. White is going to guide us through that.
Yeah, wonderful. Thank you so much, Chair Urban. It is my pleasure to present the proposed board meeting calendar for the 2026 year. So my presentation is going to include proposed dates, locations, and topics. Next slide, please. So what I'm presenting now is staff's proposal, and our proposal follows what's outlined in the board member handbook. This includes quarterly meetings, which would be held the first Friday of the month. These meetings would be hosted in Sacramento, San Francisco, and Southern California. We plan to host the Southern California meeting at the California Air Resources Board in Riverside. Meetings will continue to be hybrid. In addition, we could add on Thursday meetings the day before a board meeting, and these meetings would be focused on general education sessions. Thursdays could be a half day. And a noted change from 2025, we are no longer recommending monthly holds for the board. Next slide, please. Doing a little deeper dive into these Thursday meetings, this is based on the board's expressed interest in educational sessions. Just to talk about the process a little bit, the board will determine the educational session topics. The board will propose those topics, and if you have a speaker that you'd like to recommend for those topics, we'd certainly love to hear it. However, staff can help identify speakers, and of course, we will handle booking the speakers. Not every board meeting needs to have a Thursday session. It will be completely at the board's discretion. We propose starting these educational sessions the second meeting of 2026. This allows the board time to think about the topics they would like to hear and suggest them at the first board meeting of 2026. Although, of course, I'm happy to hear any ideas that you have now. That's just a thought. And also just a caution that staff is going to need some time to identify the speakers and book them. So again, that's another reason why we recommend perhaps not doing this the first meeting of 2026, but certainly thereafter. Next slide, please. So now on to proposed dates and locations. For 2026, we're proposing 2 meetings in Sacramento, 1 meeting in San Francisco here at CPUC, and 1 meeting down at Riverside at the California Air Resources Board Auditorium. Based on the dates outlined in the board handbook and room availability in Sacramento, San Francisco, and LA, we are proposing the first board meeting of the year to be held on Friday, February 6th. That meeting would be held in Sacramento. The next board meeting of the year would be held on Friday, May 1st, although the educational session would be on Thursday, April 30th. That would also be recommended to be hosted in Sacramento. Moving on to the summer months, we would have the Friday, August 7th board meeting held in San Francisco. Again, the educational session would be Thursday, August 6th. And then the final board meeting of the year would be held Friday, November 6th. We were recommending that be held in Riverside, and the educational session would be held on Thursday, November 5th. Now, some of these dates do have multiple location options. So what I've recommended up here, what staff's recommending up here are just options, but we do have some flexibility with these dates in terms of shifting the locations.
Wonderful. Ms. White, could we maybe talk about the dates and then talk about the topics?
Oh, yeah, of course.
Just because we have them in front of us.
Yeah, most certainly.
So the dates are fine. I will say, I understand the Super Bowl is going to be in San Francisco on February 6th, so that makes a lot of sense.
It does.
I may have to join remotely that day. There will be a lot of traffic between San Francisco and Sacramento, and that is also within the 14 to 16 weeks. It's about 14 weeks during which I have a very heavy teaching schedule and not a lot of options for travel. So that's just a heads up that for my part, that may be important. The remote option may be important. Secondly, for the August 6th and 7th and the November 5th and November 6th meetings, first of all, I'm really excited that you've been able to find a location in Southern California. I know that's been a challenge, and I think it's really important. I would ask that we swap the locations of those meetings, and it's for the same reason. It's very, very difficult. I don't know that I could get to Southern California in November, but I absolutely could do it in August. And so I would make that request. Other comments on the dates?
No, they'll work.
Okay, thank you, Mr. Liebert.
I just wanted to mention the Sacramento locations, I think, were well thought out as well, because the February, April dates, of course, are when the session's going on. And I've heard from lots of people that it'd be great for board members to have a chance to, I know you already do that, but to meet with folks up there. So that'll be great.
Wonderful. Yes, and just Chair Urban, to let you know that switching of those locations will not be an issue. I've made a note. There are some times where certain locations were not available.
Right.
That's not the instance here, so that would be quite all right.
Thank you.
Great. And then just for, the board's information, we did check all these dates against major US and California holidays, as well as religious holidays. And then I know Chair Urban also pointed this out already, but we checked them again against major events in California, including the World Cup and the Super Bowl. Hence why we are not recommending doing one here in San Francisco the weekend of the Super Bowl. Determining 2026 meetings now definitely allows us to secure the reservations in advance, which is very important because we are we were asking other state agencies to allow us to rent their space, what they've kindly allowed us to do. So we appreciate you all allowing us to book these so early, and it also helps staff plan their work for the year ahead. Next slide, please. So now we're moving on to proposed calendarized topics. And the following slides are going to outline the agenda items for each meeting. So for each meeting, I am only noting the item for Friday, since those Thursday meetings will be at the board's discretion. Another important note, some of these items may shift at the board's direction or the agency's need. Next slide, please. So looking at February 2026, reminder, we are not suggesting a Thursday meeting for this one. We plan to hold it in Sacramento, and it would be held Friday, February 6th. Standing items would be including 2 administrative topics. It's the Executive Director's annual review and also the annual administrative update. Next slide, please. Moving on to May 2026, again, this would be May 1st. This could be our first meeting to include an informational session, which would be hosted on Thursday, April 30th. The board meeting would take place on May 1st. And as mentioned, this would be in Sacramento. Standing topics include from our legislative division, the board hears and takes positions on pending legislation. Our enforcement team will provide their annual enforcement update, and public affairs will provide our annual public affairs update.
And we'll hear about the drop system.
And we'll hear a lot about drop. I'm very excited for that one. Next slide, please. Moving on to August, once again, this could have an informational session on Thursday, August 6th. The board meeting would be on Friday, August 7th. This meeting would be in San Francisco, although we could certainly move it to Riverside. Standing topics included an administrative item, budget planning for the upcoming year, and another administrative item, annual hiring update, including diversity and inclusion metrics. Next slide, please. And then the final meeting for 2026 would be held in November. The informational session could be November 5th, board meeting on Friday, November 6th. This meeting would be held probably in, I guess we would move that to San Francisco, correct? Yes. So not Riverside. Standing topics would include from our legislative team, annual legislative proposal and priorities. They would also, much like today, provide an update on annual intergovernment affairs and priorities. Our public affairs team will provide the 2027 board calendar, and then our legal team will also provide regulation proposals and priorities. And that concludes my presentation. Happy to answer any questions that you have.
Wonderful, thank you. Questions or comments from the board? It breaks my head to think about the 2027 calendar, but I very much appreciate the planning ahead. Is there public comment on this item?
All right, if you'd like to make a public comment on our agenda item 7, 2026 board meeting calendar, please raise your hand using the raised hand feature or by pressing *9 if you're joining us by phone. This is for agenda item number 7. Okay. Madam Chair, I'm not seeing any hands raised at this time.
Thank you very much. Thanks again to Ms. White's team and everybody who had input into the calendar. I know there were more than just yourself, so it's much appreciated. With that, we'll move to agenda item number 8, which is the item I mentioned at the top of the meeting for public comment on items not on the agenda. During this item, members of the public may raise comments on topics that are not on the agenda for today. The board cannot, and as a reminder, the board cannot discuss or act on any matter raised during this public comment section, other than to decide whether to place the matter on the agenda of a future meeting. And I will give a heads up that we have an item for that following this one. So we would take that up at that time. We are listening. We cannot respond, but that is to ensure that both the commenters and the board's objectives are met, not because we're not paying attention. We absolutely are. So Ms. Carwile, are there any comments on this item?
Okay, this is on agenda item number 8. Public comment on items not on the agenda. If you're here in person, you can make a comment at the podium. Okay. Or if you're joining us by phone, use the raised hand feature. If you're joining us by Zoom, I apologize, or by phone, *9. And this is again on public comments on items not on our agenda.
And I do have a public comment from a member of the public who wished to remain anonymous and asked that I read this.
Certainly, absolutely.
Perfect. Okay. It starts, I am a California resident and have been trying to exercise my privacy rights and have run into all kinds of evasions. Here's my list of concerns. Concerned about having medical data created about me without my knowledge over objection. Clothing retailer accessibility intelligence, psychological trends, and aptitude. Medical data cannot be deleted, I understand. As AI gets better, I can foresee a time in the future when it is considered a valid medical option. New York Times article on November 6, 2025 discusses federal government mulling designation therapy chatbots as medical device subject to regulation. Need to be able to buy food, don't want to be subjected to facial recognition, retina scanning to buy food. Grocery store says it collects both, assesses psychological trends. Don't want to have the food I buy tracked or ailments deduced by scanning my body. Concerned about delete exceptions. Security, legal exceptions very broad. Can a company retain your information because it failed to comply with the privacy law to provide your data? So now you are at legal risk, so it can keep your data? Concern about exemptions to right to know. Not required to provide biometric data. What they are not required to disclose is at risk of not requiring to provide information they cannot determine is you. Appears to be abusive by companies. Idea, requirement for interactive process. Inadequate sanctions for bad behavior. Lack of private right to sue, independent of our hardworking enforcers /AG to have time to pursue. Thank you very much for the incredible work that the agency has done to date. California resident.
Thank you. Greg, I'm going to unmute you at this time. You'll have 3 minutes. Go ahead and begin when you're ready.
I just checking that this may be the better place to suggests that the privacy aspects of the new digital credentials that are being worked on and standardized and starting to be deployed should be taken up as an agenda item here, partially because California is now taking the lead on privacy. We used to have representatives coming to some of the standards bodies from the federal government in places like NIST, no longer, which you might understand. So those of us working on these standards miss the support for privacy that we were getting, that we would previously got from places like NSF, DARPA, NIST, et cetera, from those privacy advocates that used to be with the federal government. So that's the angle coming from. And California has started to lead the way with the new digital driver's licenses. And as we go to the next stage of credentials, we want to have privacy enhancing. That's an area I work on very technically with the cryptography. And that's the item I'd like to bring up. And people can contact me or people at the W3C for more information and like a briefing in the future. Thank you.
Thank you for your comment. Again, this is on agenda item number 8. We're taking public comment on items not on the agenda. Madam Chair, I'm not seeing any further hands raised at this time.
Thank you, Ms. Carwell, and thank you very much to the two commenters for sharing their thoughts under this agenda item. We now move to agenda item number 9, future agenda items, which is the item for discussion of potential future agenda items. I'm pleased to handle this item. I do have a running list I went through last time. I wasn't planning to go through it in great detail this time. I will mention that some things have come up today. For example, GDPR adequacy as an issue. Some of the topics for rulemaking we have discussed. We've been discussing informational sessions for the board as well. I did want to highlight again Ms. Hamer's request from last time for legal briefing on the fourth party issue that was brought up by a public comment during that session, and I have presented demo on drop, which has happened, and thank you again for that. Are there additional agenda items from the board you would like to bring up? Mr. Liebert, no? Ms. Hamer, no? Wonderful. Are there any public comments on this item, Ms. Carwell?
All right, this is for agenda item, future agenda items. If you'd like to make a comment at this time, please raise your hand using the raised hand feature on your Zoom or pressing *9 if you're joining us by phone. This is for item number 9, future agenda items. Madam Chair, I'm not seeing any hands raised at this time.
Thank you very much, Ms. Carwile. With that, we have already taken up agenda item number 10 earlier in the day, which leaves our final agenda item, number 11, adjournment. I'd like to thank everyone, the board members, staff, and the members of the public for their many contributions to the board's work and to the meeting today. May I have a motion to adjourn the meeting?
Can, I so move.
I have a motion and a second, and you both were on deck because we're the merry band left. So I have a motion to adjourn the meeting and a second from Mr. Liebert and a second from Ms. Hamer. Ms. Carwell, will you please conduct the vote?
Yes, the motion is to adjourn. Board Member Hamer?
Aye.
Board Member Liebert?
Aye, with great thanks to the staff. Another great presentation today. Really appreciate it.
Chair Urban?
Aye.
Madam Chair, you have 3 yeses to adjourn.
Thank you very much. The motion has been approved by a vote of 3-0, and this meeting of the California Privacy Protection Agency Board stands adjourned with our great thanks.